Yeah, please. In the step item number 10, the admission second item, Malas. I'm obtaining the counsel of the other side, Malas. I'm praying for an adjournment of this matter, Malas.
Item number 10.
I don't know, 10. 2 weeks, Malas.
Well, I am for the respondent, my lord. And kindly a date may be fixed, my lord, in this matter.
Okay. As agreed by learned advocates about the parties, recessal list the matter
On 25th, 11.
Highly obliged, Malas.
May privilege. I have filed one application for vacation of one order. That order was passed in an IA for staying the proceeding of the judgment of the tribunal without there being any direction for deposit. So let this matter come up next week any day.
Take a date from him. When the order was passed? When that order was passed?
That order was passed on to 28th of 8, 28/8.
On 13th. 13th.
Maybe listeners. In connection with item number 11, Your Lordship,
Yes.
I have filed a IA for correction of the address of respondent number 7. But IA is not record. So come next week with the record. Your Lordship. I have filed on 29 10, guys.
Mr. S. Islam, learned counsel for the petitioner. Principal listing the matter on
On 18th.
18.
fair lot.
May I please,
Yes,
your lordship?
yes.
My lord, I have 5 numbers of LA appeal, my lord. Because the appeal was listed on 18/1/2024. May I bring for listing on next week, my lord,
For hearing.
hearing
5 appeals.
Hearing.
5 numbers, 5 cases.
5 LA cases, analogous cases. my lord.
In the month of December. I'll give it.
Yes.
May I please, I would like to mention one MEC bill of 2022, which is to be listed under order column. The claimant appellant is now bedridden due to suffering from some disease. Lordship, it may come on 18, Lordship, under order column first.
Okay.
18 November.
18th.
May I please, Lordship? Therefore, listing Lordship in MACP for hearing Lordship.
When?
12th Lordship, urgency is there, the Lordship, 50% amount not granted.
12 possible.
No, Lordship,
Lordship,
hearing
10th,
already
14th.
November full, Lordship. In the last week of this month,
Lordship, 14
28.
or 19 Lordship.
19. Okay, 19.
Please, Lordship.
Hmm.
May I pray for listing of a CRP, Lordship. It's in the order column. Lordship, what is it?
When?
Lordship, on 11 if possible.
11. Okay.
Okay.
Wait, please, Lordship. Lordship, I beg to mention item number 13, Lordship.
Yes.
Lordship, in this matter, Counsel Mr. A.K. Gupta has some personal difficulty, Lordship. I have taken the consent.
I am for the
That-
appealant, your lordship. I am for the appealant.
Any objection?
No objection, lordship. The only thing is, can it come up on 13/11, your lordship? 13
Okay.
November.
Yes, Lord.
Ms. M. Nirola, learned counsel appearing on behalf of Mr. A.K. Gupta. Learned counsel for the respondent with consent from the other side. Press for listening the matter on.
13 November. 13/11, your lordship.
Okay.
Obliged.
Highly obliged.
Please, your lordship, what's the date to mention for listing of an IA, your lordship, on order column on Monday, your lordship. We filed this IA for condonation of delay in RFA, your lordship. Obliged, your lordship.
May I please, lordship? Lordship, I am preparing for listing a MSc appeal, lordship.
When?
For hearing, lordship. Any that, lordship, this month.
This month not
December,
possible.
December.
Next
On-
month.
Lordship, thing is that this 2016 matter, lordship.
Maybe. Many
Okay.
other matters are there.
10th December.
10th December.
On 10th December.
In November, not possible.
Lordship, last week of November.
No,
Not
Lordship.
possible. Not possible. Your matter may not reach on that day. Already we have fixed a lot of matters. Yes.
Okay.
It is Lordship. Lordship, I beg to mention a matter for listing. It's an FAO of the year 2022. Listed last year.
In which column?
What is your Lordship?
Order.
Yes, Your Lordship.
When?
I'll leave it to your Lordship.
On 22nd.
22nd. I'm grateful, Your Lordship. I'm grateful.
May I please, Lordship? I beg to mention for listing matter CRP into C/23. It is a civil matter. Kindly list the matter on 11 November.
11.
No.
In which column? Order column or hearing column?
For order,
Order.
lordship.
May I beg your lordship, I beg to mention CRP lordship for listing
Hmm.
in orders column,
When?
13th of November.
13th, we have given already few cases on 18th. On 18th,
Okay. May it please your lordship, I beg to mention item number 38 of the supplementary list, your lordship.
Yes.
Your lordship, on the last occasion, we were supposed to file our deed of agreement and brought it on records today, but due to some personal difficulties of the appellant, we were not able to do. And today we will bring. My lord, may I kindly fix a date on the next week if possible? With sign.
You are appearing on behalf of
Mr. GN Sahebalal, your lordship.
Miss.
K. Sharma.
Have you informed the other side?
Yes, lordship, we have informed.
Miss, your good name?
K. Sharma, your lordship.
Learned counsel appearing on behalf of Mr. G.N. Sayola, learned counsel for the appellant, with consent from the other side, press for listing the matter on
26th,
November.
short date.
then 19th.
Much obliged.
Lordships. The MSc appeal, Lordships, on 10/9/2024, content non-appear on calls. So it may be listed for order only, 12 or 13 of this.
Not next week, lordship.
Huh?
Not next week, on 20.
May I plead your lordship, I beg to mention for listing one RSA lordship, 2013 method, last posted on 19 lordship.
In
2019.
which column?
Orders column, lordship.
Orders column, okay.
Friday lordship,
Next Friday, not possible. Next,
Monday,
On 22nd,
22nd.
Friday, 22nd.
May please your lordship, I beg to mention item number 25 of today's list, your lordship. With due consent of the other side, I am praying for an adjournment in this case, your lordship.
Mr. Buragmai, learned counsel for the appellant, press for listing the matter on.
Lordship, any date, your lordship.
Okay.
Any day, 27 November.
Your lordship.
Lordship, I beg to mention for listing of IA civil in order columns. Or for orders,
When?
Monday, maybe 11.
Monday, already given so many cases. On 20. On 18th.
Nice.
This is the lordship. Lordship, I beg to mention item number 23. In this case, lordship was pleased to call for the LCR, but I have checked whether that has not been received. So if lordship passes an order issuing reminder manner and fixes another date.
Okay. On the pair being made by Mr. M.S. Oduri, learned counsel for the accused, rest is list the matter on
On 25th.
25th. In the meantime, RSSL also issue reminder to the learned trial court for sending the scan copy of the record for tweet.
I'm deeply objective.
May I please your lordship, I'd like to mention item 22 of the daily list with consent from the other side. Your lordship, on last occasion, your honorable court has asked for the LCR. However, we have not received it yet. So you can call for a copy and list any other date feasible by.
Your good name?
Mrs. Elish Bola.
Mr. So learned counsel appearing on behalf of Ms. S.K. Nargis, learned counsel for the accused, press for listing the matter on
Any other date feasible by this.
On 27th November.
Most of it.
RSSL also is a reminder to the learned trial court for transmitting the scan copy of the record for tweet. Yes.
Lordship, I beg to mention for listing of a MSc appeal, lordship.
When?
Lordship on 30th.
In which column?
Orders, lordship.
Orders.
Orders.
Orders, lordship.
Item for withdrawal. Item number 35.
Allow to withdraw this petition.
Mr. P.J. Dotto, learned the petitioner submits that he has the instruction to withdraw this petition. Accordingly, this transfer petition, within bracket C, stands a disposal on withdrawal. Liberty will be required.
Yes, lordship.
However, liberty will remain with the petitioner to approach this court again by filing an appropriate petition.
For motion item 1,
This is a transfer petition, transferring of a civil case, matrimonial case from family court Guwahati to Borpeta.
What is the ground?
The first ground is that she is a lady and orphan, has no mother or father. Her parents died early in her age, and only one brother is there at Borpeta. Second thing is, my lord, she has been tortured mentally and physically brutally, my lord. So there is no scope to come to Guwahati alone, my lord. Third point is that the husband is a government employee who is at disaster management at Guwahati.
Okay. Heard, Mr. Your good name?
DK Nath.
Learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is referred by the petitioner for transferring of FC civil case number 950 of 2024 pending before the Court of Learned Principal Judge Family Court number 3 Kamrup Guwahati to the Court of Principal Judge Family Court at Borpeta. Mr. Nath, learned counsel for the petitioner, submits that the petitioner is the respondent in the title suit.
My lord.
In the
civil.
FC civil case number
FC.
950 of 2024 instituted by the respondent herein,
My lord.
comma, the husband of the petitioner for
Restitution of-
granting divorce.
No, my lord, restitution of conjugal right. Page 14, my lord, annex 2 is the notice. This is another problem, my lord. So he wishes to
For-
restitute. Page 14, my lord.
Where it is mentioned for restitution of
My
conjugal
lord,
right.
the third line. Second line, under section 9 of Hindu Marriage Act for restitution of conjugal right.
For restitution of conjugal right under section 9 of the Hindu Marriage Act 1955. And that the respondent herein is working in the disaster management department of the government of Assam, and the petitioner is presently residing at Borpeta, and she is unable to appear in the family court at Guwahati to contest the aforesaid case instituted by her husband, and therefore it is contended to allow the petition. Having heard the submission of learned counsel for the petitioner, I have gone through the petition and the documents placed in the record. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. And considering the submission of Mr. Nath, learned counsel for the petition. So, considering the facts and circumstances on the record, this court is inclined to stay further proceeding of the FC civil case number 950 of 2024 pending before the Court of Learned Principal Judge Family Court number 3 Kamrup M till a returnable date. List after 4 weeks.
Apply.
Item number 2.
May it please, Your Lordship. Lordship, I'm the plaintiff in the instant case. Under section 6 of the specific relief act for recovery of khas possession and
Whether appeal will lie or revision will lie.
revision will lie because under section 6 of the specific relief act, section 6 clause 2, it says that clause 3, no appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. So, civil revision petition. So,
Whether the suit was registered under the said section.
yes, I think, Your Lordship. The claim, Your Lordship will find at page 18. 18 and the page 18, the claim, Your Lordship will find
suit for recovery of possession and further granting permanent injunction under section 6. So this is under section 6. So that's
Heard
what-
Mr. Dotto, learned counsel for the petitioner. This revision petition is directed against the judgment and decree hospital learned Munship number 1, not looking for in title suit number 53 of 2021. It is to be noted here that by the impugned judgment and decree dated so and so, the learned Munship number 1 has dismissed the title suit instituted by the present petitioner. Under section 6 of the specific relief act 1963. Peruse the petition and the documents placed on record, and also peruse the impugned order, judgment on the impugned judgment and decree dated 5th of July 2024. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Recessal call for the record from the learned trial court. List the matter after 4 weeks. Interim pair will be considered on the next returnable date.
Your lordship, in the next returnable date, it may be stayed, the impugned decree. That is not real.
Not now. That we will consider.
Item
Because
number,
possession is not with you.
Possession is not with me.
Yes.
item number 3,
Right.
Please, Your Lordship. Lordship, under Article 2 to 7 of the Constitution, Your Lordship, I reduce section 115 of the CPC, Lordship. In this case, Lordship, 3 orders have been challenged, Lordship, in FC Civil 2375 of 2024, Lordship. The petitioner is
No, you see, the matter was referred to conciliator
Lordship.
and
Only one counseling was done, Lordship. That's why
how many counselings are required?
Lordship, counseling exact number is not required, Lordship.
Then
So far, section 9(1) of the Family Court Act is concerned, Lordship.
mm,
Every endeavor should be
mm.
made by the family court.
That means from the
for
very
conciliation.
beginning till end of trial, the conciliation process has to be going on. Is it your submission?
No, Lordship, at least the other chances
What
I-
other chances?
might have been given, Lordship, because the petitioner dreams of some amicable settlement, Lordship. That's why he filed a petition, Lordship. But
What amicable settlement? The wife is suffering from cancer.
Lordship,
She is at the 4th stage of the cancer. And you have got married again,
Lordship. Lordship,
and now you are resisting the petition.
so Lordship, I have children, Lordship. She has been suffering from cancer since 2019, Lordship. So to look after, there is none. Lordship.
You saw how the impugned orders are arbitrary and illegal.
Lordship, Lordship, 3 orders have been challenged, Lordship. If I come to the second one, Lordship.
Mm.
Lordship, during pendency of this case, Lordship, the respondent wife, Lordship, filed a petition under Order 6, Rule 17 for amendment of the claim, Lordship. Lordship, that prayer of the respondent wife was allowed, Lordship, after 102 days, Lordship. Because for the fact that, Lordship, the respondent wife could not file the amended claim, Lordship, once order, since the date of order of permission, Lordship, since the respondent wife could not file the amended claim within 14 days from the date of order, Lordship, therefore, Lordship, the petitioner husband filed a petition under Order 6, Rule 80 for not allowing the respondent wife to file the amended claim, Lordship. But even that, Lordship, the learned court below, after 102 days, Lordship, allowed the respondent wife to file the amended claim, Lordship. It is quite illegal, Lordship, because it is the mandate of Lordship, it is the mandate of law that within 14 days, Lordship, amended claim is to be filed, Lordship. But the learned court below was pleased to allow the wife to file the amended claim, Lordship. But that too, Lordship, without any application, Lordship, made by the respondent wife, Lordship. This is illegal, Lordship. This is contrary to the law, Lordship. And third point, Lordship, on the last, thereafter, Lordship, during pendency of this case, Lordship, since the marriage certificate, Lordship, is disputed document, Lordship. Therefore, Lordship, the petitioner filed a petition under Order 11, Rule 70, Lordship, for production of the documents, Lordship.
You see, by the second order, the trial court has not dismissed your petition. It has only been observed that the petition is premature.
Second order, page 94, Lordship, page 94. May I read out relevant portion, Lordship, page 96, Lordship? Peruse the case report, it reveals that while order dated 27/5/2024, this court, after hearing the representative of the
No,
petition-
you come to page number, internal page number 7.
Page 7. Page 7 here. I have got it, Johnny.
Yes, the present petition dated 24/7/2024 filed by the petitioner is premature.
Lordship, how can it be premature, Lordship? No. The commission of this court for amending the same, the petitioner did not file the amended claim as required under Order 6, Rule 18 of CPC, and during pendency of this petition, another petition for amendment cannot be decided. During pendency of the case, another amendment petition was filed by the respondent wife, Lordship. The present petition dated 24/7/2024 filed by the petitioner is premature. The present petition, that means, the present petition, it means the petitioner of the respondent wife, Lordship. It is not the petitioner, Lordship. The present petition, so and so, the petition under section 151 CPC has sought for permanent alimony of rupees 10 lakhs and for payment of expenses incurred for medical treatment of cancer of the petitioner, and also for amending by way of insertion of prayer for the permanent alimony and not to grant medical expenses for the treatment of the petitioner and for the expenses for the proceeding, but without obtaining prior permission of this court, the petitioner does not have right to file petition for permanent alimony or for pending.
Okay, at this instance, we will issue notice only. Or Mr. A.K. Ahmed,
So further trial of this case may kindly.
sorry. No stay,
Lordship, this is not my petition, Lordship. This is her petition, Lordship.
maybe. Heard, Mr.
A.K. Ahmed, Lordship.
Learned counsel for the petitioner, and also this petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, is referred by the petitioner, challenging the correctness of the order dated 24/7/2024 7/9/2024 and 22/10/2024 passed by the learned Principal Judge Family Court number 3, Ulubari, Guwahati in FC case FC within bracket civil case number 1275 of 2023. Peruse the petition and the documents placed on record and also peruse the order dated 24/7/2024, 7/9/2024 and 22/10/2024. That notice be issued to the respondent returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Lordship, may submit lordship on order 22nd of October 2024, lordship, at page 115, lordship. Just, I would like to read out the order, lordship.
Not necessary.
Lordship, even this petition was refused to accept by the petitioner, lordship. And lordship, though the petitioner wife was not accepting the petition, even the learned court below was pleased to hear the
Interim pair to stay the proceedings at this stage is rejected.
Item 4,
Much obliged.
May I please, your Lordship? Lordship, the order dated 9/7/24 passed by the learned.
What is the ground?
Well, the ground is for rejection mainly for due to want of cause of action. Because suit is for specific performance of contract. And the admitted case of the plaintiff is that Lordship, the plaintiff, Lordship will find from page number, my lord, 16. So Lordship may be.
Whether at that stage cause of action can be presence or absence of cause of action can be determined.
Yes, my lord. As because of the
How?
admitted facts.
How?
I'm showing, my lord. Kindly, Lordship may be pleased to peruse para 2 of the plain, that is at page 19. Page 19, my lord. So in para 1, there is a reference of one registered agreement for cell number 1332 dated 24th day of May 2018. And that is the document number 1 relied by the plaintiffs. Thereafter, in para 2, my lord, it is said that in subsequent to the aforesaid agreement for sale, the defendant entered into a memorandum of understanding with the plaintiffs for the sale of Cedil A land with new terms and conditions by registered memorandum of understanding deed number so and so dated 13/10/2020. As because the plaintiff number 1 did not fulfill the obligations of the agreement dated 24th May 2018 within the time frame. This part is important. Plaintiff number 1, he didn't fulfill. But even then, in the suit, he is the plaintiff number 1. So it is also stated that the agreement dated 24th May
So
2018.
what is the
has been cancelled.
observation made by the trial court?
Observation, my lord, Lordship will find the impugn order from page number 119. And the operative part, it starts from 120, page number 120. I am reading the first, second, third, fourth paragraph, my lord. The principal contention of the petitioner defendant number 1 in filing of the instant petition is that a memorandum of understanding was entered into between the parties as per which rupees 1 crore to be paid by the plaintiff number 2 and another person to the defendant number 2 within 6 months of such execution, which was not paid. And hence time was essence of the agreement, which then bars the filing of the instant suit. This contention of the petitioner defendant number 1 has been refuted by the OPs. The question whether time was essence of the memorandum of understanding can be decided in the trial of the title suit. And
So, Mr. Bora,
yes, my
the
lord.
trial court has observed that the issue is a mixed question of law and facts,
Yes,
which has to be decided on the basis of evidence adduced and documents exhibited.
yes, my lord.
So is it not premature to consider at that stage the
Yes,
issue
my lord.
raised by you?
This very question was also raised by the learned trial court also. But my lord, the point is, I am strictly confined to the statements made by the plaintiffs in the plain as well as the documents relied by them. So when the document says that there is a clause for payment of rupees this 1 crore within a time frame. And in that memorandum of understanding, it is also stated what will be the consequence if that is not paid. And there is no any statement in the entire plane that this rupees 1 crore was paid.
Okay, let notice go ahead. This.
So, my lord, kindly the further proceeding may also be.
Next that let the other side appear. We will consider you appear.
Yes, my lord.
Heard Mr. Bora, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the order dated 9/7/2024, passed by the learned Civil Judge Senior Division Kamrup M. And the Kamrup Amin Gao in Mijek is number 260 of 2023, arising out of title suit number 81 of 2023. It is to be noted here that by the impugn order dated so the learned trial court has dismissed the petition filed by the petitioner under Order 7 Rule 11, read with Section 151 CPC. Peruse the petition and the documents placed on record and the impugn order dated 9/7/2024. Let notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. Interim pair of the petitioner will be considered on next date.
Order number 5.
My lord, here this is a case between two sisters.
So why the WS could not be filed in time?
My lord, I have annexed the medical documents also.
Where? Page number?
Page number, my lord. It starts from that I was also out of station. My lord, annexer. My lord, from page number 29. Husbands, the petitioners. From 29 to, my lord, page number 47. So there is a probate case also pending there. In the probate case, I am the plaintiff. And the plaintiff is the defendant there. Regarding the same property, here she sought for partition, and there the property was given to me. Lots of medical documents, my lord. I was also out of station for some time. Plane tickets are also there. I have annexed, my lord. Page number 42, there is a plane ticket also. Coming from Kolkata to Guwahati, my lord. In February 24. In connection with this medical purpose, I have to visit several places, my lord. All the medical documents outside the state of Assam, my lord, more or less. Till 29, it is of Bangalore. It is of 1/8/2023. Case number 23 itself shows in history that patient is wheelchair bound.
Which document?
Case number 29, my lord. The history portion. Husband of the petitioner, he is wheelchair bound. Reflexes all diminished. I have to accompany my husband. For a long time, he is still under medical care and attention, my lord.
So you are not suffering from any disease?
No, I am also. My lord. Namaskar, Manjari. Sujata. Yes, Sujata. My lord, page 36. 36, my lord, 37, 38. These are all treatment carried outside the state of Assam, my lord. Thereafter, page number 40. My lord, in air ticket also, my name is there along with my husband. 44, a certificate is also there. Partition suit, my lord, at least I have the right to contest. Because if the suit goes ex parte, then the probate case will also apply.
That's all right, but you have to show the sufficient cause, no? Whether you have submitted these documents before the trial court.
Well, yes, on the, when we filed the WS event.
So where
along
is
with
the relevant?
WS, my lord, we have filed an application.
No,
for
where is the,
accepting.
Bora, where is the relevant observation in the impugn order?
Relevant observation, my lord. My lord, from page number my lord, 108. 108. Page number 108, para 10 onwards, my lord.
108.
Page
There is
number.
no page number 108. 108.
Impugn order, my lord, it starts from 104 internal page number. It is 5 of the order. Impugn order. That is 222/23.
Paragraph number.
Paragraph number 10, my lord. Considering the provisions of section 151 of the CPC, it is evident that this provision can only be exercised to prevent the miscarriage of justice or the abuse of the process of law. In this case, the procedure followed by the court did not create any hardship or any abuse process upon which the provision of section 151 may be used. Consequently, it is seen that the petition filed under section 151 of CPC appears to be not justifiable for the acceptance of the written statement. However, it is worth noting that the learned counsel appearing on behalf of the defendant number 1 was appointed as the attorney of the defendant number 1, earlier counsel, my lord. And without the direction or advice of the defendant number 1, the learned counsel would not have filed an application for adjournment without showing the reason for the medical treatment of the defendant number 1. This fact indicates that the reason of medical treatment is newly pleaded in the petition filed under section 151 of CPC by the newly engaged counsel of the defendant number 1. Upon careful consideration of the circumstances, the court has determined that the petition for acceptance of the written statement was submitted after a significant delay of nearly 5 months by the newly engaged counsel. The stated reason for the delay attributed to the medical treatment of the defendant number 1 was not previously cited by the former counsel in earlier applications. This lack of disclosure indicates that the defendant did not approach the court with clean hands. Accordingly, in adherence to the principles of equity, the court finds no justifiable reason to accept the written statement through the application of his jurisdiction under section 151 of CPC. Consequently, the court is of the opinion that defendant number 1's prayer lacks merit and is thus rejected. However, the defendant will be allowed to present before the trial and cross-examine the plaintiff's witness on relevant legal points should such circumstances arise. Petition
What is
number
says
1.
the case is pending now?
My lord, it is now for SR, the service report. My lord, here are other defendants. There are several defendants, my lord.
This
Page 16 onwards.
this 5 months start from which date?
My
Paragraph
lord,
number 12, it is observed that delay of nearly 5 months.
my lord, this was instituted in the year 2023. That the suit was instituted on April 29, 23. That lordship will find in page number 106.
And on November 3, 2023, the defendant number 1 through her counsel prayed for adjournment. So on 1st of
When
November.
you have received notice, summon.
Someone, my lord. What is the name? One. Puninavan Palama Pavasana. My lord, I have engaged my counsel initially on 23/8/2023. I have stated in para 3.
No, you tell me the date on which you have received the summon, because from that date,
Yes, that has to
the
be
90 days
yes,
has
my
to be
lord.
counted.
My lord, that has to be seen, my lord.
Okay, we'll take it up later on. You go through the record then.
My lord, then day after tomorrow.
Day after tomorrow.
Day after tomorrow.
Okay, on the pair being made by Mr. Bora, learned counsel for the petitioner, SSL. Friday.
8. Okay. Item number 6.
So as to enable him to go through the records and to apprise this court from on which that the petitioner has received the summon.
Item 6.
Please, your lordship.
Yes.
My lord, in application under Article 227 for interpreted order, because what happened, my lord, plaintiff had filed a monies suit claiming that some amounts are due for supplying of some goods, my lord, which is not done. Now, we have, I cannot, the village also have filed. They have to, when preliminary hearing is that they have filed an application under the 11 of 2 for, they are telling, submission is that they do not have the original documents. And being a defendant, I have original documents. So we are categorically denying all this point because with this, our submission is then and points for arguing and defending on the entire case as well as then the defendant that items are not being supplied to us. That is our stand on that. Now, we have filed also written objection to that effect, but trial court had directed us to place original now. We do not have the original as I stated in our place also, we stated in our written objection also. That is our stand because we do not have this because this is a plaintiff. The plaintiff has shown some documents, but this is now he's telling that he doesn't have. He not even as a documents. Also, he has not furnished that documents. They are insisting on us. We do not have. That is our stand, my lord. If the honorable Liner trial court directs us to produce original, and we do not have that. It is only reason, my lord, I have here before lordship. Let notice goes, my lord, further proceeding. For time being, maybe next date is done. 27/11/2024 for necessary order. Thereafter, we have filed one application also under provision of section 151. It is also not been disposed of anyhow. But anyhow, that will, because this main order is there. I mean, that is why my humble prayer before your honor today, notice may go in further proceeding may be there. Our entire defending points are saying that this items are not being supplied to us.
You produce the documents or whatever documents are available with you.
No, because
why staying of proceeding is necessary?
Documents for
because this is a money suit.
No, because it's criminal. But documents you do not have. That documents which is directed by the trial court to produce this, we do not have documents, my lord. We're categorically saying that is.
So where is the petition? This petition number 1351 of 2023.
And it is 3233 page number. Got it. Reason, there is application under order 11 to rule 14 which so and so. This is a case today fixed for preliminary and that at the time of filing should the plaintiff had filed copies of the documents relied by him. The original documents are mentioned in the annex here to are lying with the defendant. That original documents are mentioned in the list and it's here necessary for proper adjudication of the case. As such, defendant may kindly be directed to produce the same before the honorable court in case the defendant fails to produce plaintiff can be allowed to exhibit the copies of the secondary evidence. It is therefore prayed that your honorable the honorable court may be pleased to direct the defendant to produce original of the request mentioned. Here to the defendant fails to produce, be pleased to allow the exhibit the office of the judge. Now, to that effect, we have filed with an objection, my lord. It's an objection page starting from page 34. Main paragraph, this one. That petition is plaintiff based on the plaintiff has been filed to fill up the lacuna and allowing the petition to be witnesses. In this regard, statement made in so and so. In regard, the statement made in is not only to the original document mentioned in the list of the documents not lying with the defendant as the material share not received by the defense as mentioned in annex as such, there has not put his signature on this invoice, but the plaintiff falsely filed the assistant suit and has false documents against his material share supplied to defendant. That the defense so and so in this regard is saying defendant back to state that the payment is already made to the plaintiff against the delivery of materials to him. There is no outstanding payment due to plaintiff. Plaintiff has filed instant so only for illegal gain and annex some false documents showing the process. That is how we have given to that. If they also only now they are paying for this secondary release. Is there because
You now tell me how this order suffers from illegality or infirmity or arbitrariness.
illegality is only because of this, my lord. Here, lordship, may I read this order? It is
Yes.
It is lastly, the plaintiff by this petition states that plaintiff had filed copies of certain documents with the defendant. Such praise before the court direct the defendant to produce the original documents. To the same, the defendant had filed written objection state that the originals are not with the defendant as such. Praise for court to dismiss the petition. Since the petition produced the records heard the learned counsel presenting the both the parties. It is been seen that stands put is filed against the defendant number. So defendant for recovery of assess the aims of justice and the opinion that defendant to produce the documents which are in the custody as producing documents before the court will not cause any prejudice to the defendant opposite party. They will get ample opportunity to cross-examine the plaintiff along with their documents concerning such the file petition under so and so allowed. Now, this order, if we see by this, there's no infirmity. But here, their direction is there. I have to whatever documents you have. That documents are not written. These are outstanding. Now,
That's all right. Whatever documents are with you, you produce those documents.
And yes, that it will, if the time before lordship, when one not on delaying on these all cases, my intention is not there. Some observation is there because by direction, if we feel that I have to produce the documents, my understanding, I may be wrong, beloved. I may be wrong. I may have to produce some documents, which I do not have. Your lordship, little observation to clarify, because I have clarified by 151. Because this order, if clarified that whatever word also is coming up, or little, your lordship, I'm not on that this case will be delayed or this one, but it's a money issue. But by mere and bare reading of my understanding, and I'm wrong, my lord, they are asking me to produce the original documents from where? Because the document is not with me. That is why before lordship. We made them to understand. We already submitted also this one. I submitted before the trial court. Same way. But order people got.
So definitely some documents are with you.
Oh, because the documents, my fair submission before lordship today, that documents, that items which is shown, is not supplied to me. It's a question of documents, not come. These are our stand, my lord. Categorically, we are stating that whatever they are saying that goods are supplied to me, my saying is that in trial court, my submission is that items are not at all being supplied to me. Once items are not being supplied to me, from where documents will come? These are our submission only. If I have a little bit admitted, I do not have document, I have received the items, I do not have documents. Then also, lordship. But I am categorically stating that you have not received that documents. Falsely, they are claiming that. And that apart, my lord, is generally original case always kept by supplier. Generally, whatever maybe this is their business purpose, understanding, I do not understand. Only because this is why once not applies to me, documents are not with me. That is our submission.
Not a single document is available with you.
No, these documents not alone. Fairly submitting, they can produce trial little. As on get my submission before lordship, I stand also that goods will not been supplied to us. Whatever goods are not being supplied to us, question of documents may not arise, my lord. It is my humble submission before. Very fair submission to this.
So, Barwa, you produce these invoices which are listed in the petition?
These are stand, my lord. They have shown some documents. My ethical statement before lordship also, I could also it was there that.
No.
That's
I am not asking you to produce these documents from your custody, but whatever documents furnished by the petitioner,
plaintiff.
Yes, plaintiff, before the trial court, you produce these documents, we will see.
Let him produce.
No, you produce this petition is prepared by you.
That is my submission.
No, these are not in your custody, but these are filed along with the plaintiff before the trial court.
That is my submission. Statement is there. They have not filed the documents. Though they have shown the documents.
No, it is mentioned as a list of documents filed by the plaintiff.
It is, my lord. Filed the documents, it is there. But they have not furnished. That is why recorded because they have only shown this, listed, they have shown these documents. Now they are, I think, that is the problem has come up. Because they have shown the documents, they are not producing, court will also not producing. They are insisting me to produce. From where I'll produce? Let them produce at least, produce there. Where my signature is there. Let them show.
No, are you sure that these documents are not enclosed with the plaint?
Yes, it has been, I'm still in that perimeter.
No, are you sure?
I'm sure, madam, it has not been furnished.
Otherwise, we will call for the record then.
It is
Scan
in-
copy of the record.
My
We'll
lord,
examine
my
the
lord.
record.
My lord, my lord,
Hmm?
my lord.
Heard Mr. C. Barua, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 24/7/2024, passed in Manisuit number 314 of 2022, passed with the learned civil judge junior division, number 4, Kamrup M. Guwahati. Just to be noted here that by the impugn order dated so and so, the learned trial court has directed the petitioner to furnish original copy of 14 numbers of documents. Before the learned trial court. Mr. Barua, learned counsel for the petitioner, submits that the documents, list of which is enclosed with the plain, is not with him, and the same were also not enclosed with the copy of the enclosed with the plain. In view of the submission of Mr. Barua, learned counsel for the petitioner, perusal of the record is found to be necessary, and accordingly it is provided that Registry shall call for the scan copy of the record from the learned trial court, fixing the matter on next Monday.
On 11th.
Like,
Item number 7.
This is matter is relating to acceptance of my written statement.
How many days?
The case is
Delay of how many days?
delay of 210 days.
What is the ground?
Ground is that I am a defense personnel and my duty is in Assam Rifles. And since 2020, I am posted in Tamenglong district of Manipur. But this suit is filed in the year 2022 and that address is not shown. Address is shown at this thing, Sadgaon, Kochpara, here at Guwahati. And when I came on leave on 11th of January 2022, on the very next day, the summon was
Notice was served upon you at
Sadgaon. I came on leave. My leave was for 45 days.
So,
I
who is there in your residence at Sadgaon?
Sadgaon, my wife and my family, children are there.
They have received the notice?
No, it was given to me. On 12th, they have taken these steps, and on that very date itself, I was given. On 11th, I came here on leave. And after getting the receipt of this summons, only the plain copy of the plaint was given. No document, nothing was given to me. And when I tried to get the copies from the certified copies, it was not possible within the limited period of my leave. So I had to go back. Again, I tried to come in the month of May, but because of this landslip and incessant rain in Dima Hasao, I could not come. Rail as well as by road, it was all blocked. For days together, I came in the national news also. Thereafter, I could get the leave in the month of October 2022. When I came here, I find that it is a civil holiday. My thing was not materialized, so I accordingly given power of attorney to my wife on 13/10/2022, and my wife and I had to go back to report my duty. So thereafter, my wife has submitted
No,
the
no,
written.
no. When the notice was served upon you
My lord,
at Satgao,
Satgam.
why you have not given the power of attorney to her?
My lord, I tried that I will file it. And because of the lack of documents, it should not be materialized. And thereafter, I tried at the Tamenglong also, but that is a very remote area. Power of attorney could not be possible to be executed there. I tried my level best. And as a result, there was a delay, my lord. And that delay, the learned trial court has turned out. One is on the ground.
No,
that-
the perusal of the impugn order indicates that it is a region order.
My lord, if this is a reason order, it is based on that my address is shown in the claim as Satgam. So,
No, someone was served upon you.
my lord, someone without document, the very impugn order says that it was not given any I was not provided with any documents. That also reflects. in the
Which order says?
This order dated page number 111, annexure number 11, 110, annexure number 11. Para number, my lord, this para number 3, while the said petition, the defendant has the defense personnel working at Manipur, and on 12/1/2022, summons served up to him without any documents annexed to the claim.
That is your stand.
My lord,
That is not the observation of the court
my lord,
or finding of the court.
my lord, the step that was taken on me is only the copy of the claim was given, not even the miscase. Miscase also, for that I had to pray before the learned trial court.
Where is the affidavit you have sworn
My lord,
that you have not received any document along with the
my
plaint?
lord, in my petition, it may kindly be perused, this annexure number 8, page number 75. By this petition, I prayed to accept the written statements. And there I have categorically mentioned
Paragraph number?
my lord, this thing that here, my lord, paragraph number 2 may kindly be perused. Defendant came on his annual leave on 11/1/2022 at Guwahati, and on the very next day, that is on 12/1/2022, summon and notices were served upon the defendant in connection with the above noted suit, but without any documents annexed to the claim. And this petition, my lord, is supported by an affidavit. And my lord, the case is at a very initial stage. If my WS already filed.
What is that? At what stage it is pending?
It is pending for ex parte evidence of PW. And during this period, they have not filed any evidence. Only after this WS was rejected, thereafter they have filed the evidence. And all these days I have annexed the orders. Lordship will find that they have simply kept on taking the time. They have not, there is no progress. So at this initial stage, if it is accepted, no, it is not going to prejudice the interest of the plaintiff in any manner.
Heard Mr. Nandel, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 14/8/2024 passed by the learned civil judge, Junior Division Number 4, Kamrup,
My lord, as well as the order dated 35/2022, by which I prayed for extension of time, that was rejected.
By the learned civil judge, junior division number for Kamrup M. Guwahati. Whereby the learned trial court has refused to condone delay of 211 days and to accept his written statement in title suit number 5 of 2022. And also the order dated 38/5/2022 passed in the aforesaid title suit, by which the learned trial court has refused to grant additional time to file the written statement. Mr. Nandi, learned counsel for the petitioner, submits that in the title suit number 5 of 2022, the petitioner has received notice on 11/1,
My lord, 12 what?
12/1/2022 in connection with the aforementioned suit. But along with the notice, he has not received any of the documents annexed with the plaint. And that the petitioner is serving at Tamenglong district of Manipur, which is a remote place from where he could not take necessary step for filing written statement before the learned trial court. And when he filed and thereafter he filed a petition for extending the time for filing written statement, on which date you have filed?
I have filed it on 30.
Petition number,
Petition number is 640 of 2020.
page number,
My lord, that petition I could not annex here. This petition number 640, but it is reflected in the order. My lord, if lordship kindly peruse.
no, if you want to challenge that order, refusing to grant extension, is it not necessary to enclose the petition?
My lord, it is necessary,
Then
but
you produce it on day after tomorrow.
my lord, day after tomorrow, it may not be possible because I'll have to take the certified copy.
When? Then Monday, next Monday,
Next Monday or Tuesday may be given.
Tuesday.
Tuesday.
Okay, on the prayer being made by Mr. Nandi, learned counsel for the petitioner. Rest is the matter on Tuesday, Kobe.
Lordship on 12 Tuesday.
Tuesday. So as to enable him to produce certified copy of the petition number
640 of
640 of 2024.
2022. Deep pages.
Item number 8.
So I come against the honorable Mr. Johar, which says at page, starts at page 43, but the relevant portion is at page 47 in your lordship.
Mr. Sharma, so it is an admitted fact that your salary is 65,000 per month.
That's right, your lordship. I have against my
That is an admitted fact.
income expenditure statement was furnished, but that was not taken into consideration by the London District Judge, your lordship, because my expenditure is very high. Because to take care of my young child and my aging parents, my expenditure comes to 65,000. My income is 65,000, some or 900 something, your lordship. And my expenditure comes to 65,000. So therefore only 900
something amount is left for, that was not taken into consideration by the.
Okay,
government.
Mr. Sharma,
Okay.
we will issue notice.
That is your lordship, the main divorce petition, your lordship, that is at the stage of cross, your lordship. But a few days back, the matter was listed before the line of district judge, and it was directed that you pay the money first and then only I'll allow to cross-examination.
Definitely.
So therefore.
But
your
we
lordship,
will not stay the proceeding.
under the state, your lordship, that will remain.
So in view of the income,
Lordship.
which is an admitted fact,
That is admitted,
this
your lordship.
granting of interim maintenance of rupees 10,000 appears to be justified.
But then your lordship, that expenditure was not taken into consideration, your lordship. I have not annexed my income expenditure statement here in this petition, your lordship.
Where?
I have not annexed, but then it is with me, your lordship. I have received only
You
yesterday.
file it by filing one additional affidavit.
Lordship. Then a stay order is probably required, your lordship.
No.
Proceeding
No
of the.
stay order. This interim maintenance has to be paid. Heard Mr. Sharma, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the order dated 13/8/2024 passed by the learned district judge Surat in Miss J case number 25 of 2022 entitled suit M number 12 of 2020.
22, your lordship.
2020.
22, your lordship.
You come to page number 2 of your plaint of your petition. Miss J case is of 2022. Title suit is of 2020.
Lordship.
It is to be noted here that by the impugn order dated so the learned district judge has directed the petitioner to pay a sum of rupees 10,000 being interim maintenance and also directed to pay litigation expenses of sum of rupees 30,000 as one-time payment. Where is the petition and the documents placed on record? Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process in within a week from today.
Registered post, your lordship.
Registered post and usual process, both. Interim pair of the petitioner will be considered on next date. And in the meantime, Mr. Sharma shall furnish the affidavit disclosing his assets and liabilities of the petitioner before this court on next day.
Items for admission, item number 9.
Lordship. May I please, Lordship? Lordship, this petitioner filed a suit. He filed the title suit. Lordship, that is title suit number 353 of 2020 for decree of declaration of right title interest, recovery of possession, and for injunction. Along with this suit, an injunction application was also filed. And accordingly, after hearing the party, the injunction was paid. Injunction was granted. Directing the parties, more particularly defendants, not to alienate, not to trespass the suit property, as well to make further construction over the scheduled property. So thereafter, what happened, Lordship, by violating the order of injunction, they proceeded with the construction work as well as they have alienated the property also. Because they have constructed the defend number 1 and 2, they have constructed the building flats over that particular plot of land along with the other plot of land. I am not only respect of the others' land, but so far our case is concerned, my land is to be protected. So violation cases there, it is pending. In the meanwhile, when they are proceeding with the construction work, we file an application under section 151 of the CPC before the trial court for enforcing the order of injunction with the police help. That is also pending. But even then they are proceeding with the construction work, then under that compelling circumstances, this petitioner, Lordship, has plaintiff filed an application under Order 39 Rule 7. Order 39 Rule 7 of the CPC to protect, to preserve, and inspection of the suit property during that as the matter involved regarding the injunction. So that 7 says, Lordship, Order 39 Rule 7. Detention, preservation, inspection, etc. of the subject matter of the suit. The court may, on the application of any party to a suit, and on such terms as it may fit, make an order for detention, preservation, or inspection of any property which is the subject matter of the suit, or as to which any question may arise therein. B, for all any kinds of purpose, aforesaid authorize any persons to enter upon. I am not on that. Only Order 39 Rule 7A is applicable so far our case is concerned, because in spite of their having the order of injunction, passed after hearing the parties, final order of injunction, they are violating it. So there is a violation application was also filed. Police help application was also filed. Under that compelling circumstances, Order 39 Rule 7 was also filed. So that application has been objected by the defendant number 1 and 2. They filed the objection. And after hearing both the parties, all the parties, the learned trial court passed the impugn order. That impugn order, Your Lordship, at page 313, Annexure 16. Lordship, the relevant portion is 316. Record, Lordship got it. 316.
Yes.
Court reveals that there is an injunction order restraining the opposite parties from raising construction over the suit land, and if the opposite parties in violation of this said order has been raising construction over the same, then the petitioner may claim relief for violation of such injunction, complying due procedural law. We have filed already violation petition is there. That apart, the suit is in the initial stage, trial is yet to be begun. That being so, petition for local inspection is found to be premature. Necessity for local inspection is subject matter of the consideration after evidence of the parties. Moreover, the opposite parties have raised construction over the Schedule A land as alleged by the petitioner. Then finally, they would have to face the consequence of the suit. That being the position, I am of the considered opinion that the allowance of the petition would amount to collection of evidence if premature stage. So, Lordship, that the observation made by the learned trial court, it is not correct. That learned trial court considered my application as Order 26 Rule 9. So, Order 26 Rule 9 is a issue of commission, it is a separate chapter. Order 26 Rule 9, commission to make local investigation. My application was under order 39 rule 7. Lordship got it. In any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute. So there is evidence and further elucidation is necessary. Under that circumstances, an application may come at the argument stage also, when the court cannot come to a conclusion, arrive at a conclusion after receiving the evidence. Definitely, if the application was filed under order 26 rule 69, order 26 rule 9, definitely it is a premature stage. But my application was under order 39 rule 7, because there is an injunction order. Injunction order was passed. That has been violated. Continuously they are violating it. We prayed for inspection and learned trial court passed this order because the court was empowered to preserve and protect the property as provided under order 39 rule 7, because the injunction matter is involved. So learned trial court, without leaving aside that part of order 39 rule 7, consider that mere observation that the suit is initial stage. How? Because that is an initial stage that is to be preserved. It is not an application under order 26 rule 9. So my humble submission before this honorable court, that wrong has been committed by the learned trial court. So I prayed before the honor, that is an application we filed that during pendency of these proceedings and inspections to be made. That application of lordship, we filed it, Annexure 13, page 284. Lordship, an application filed by the plaintiff under order 39 rule 7 under section 151 of the Code of Civil Procedure for preservation and or inspection of the scheduled suit property through the bailiff Nazir of the Honorable Court and to enforce, implement the order of dated so and so passed in Mizze case number so and so. So I'm thinking. Paragraph number 13 at page 291. What was my contention? What was my prayer before the learned trial court? That the petitioner further submits that as the opposite parties, in spite of having their knowledge about the order of injunction dated 13/9/2021, as well as the subsequent application filed by the petitioner before the Honorable Court, have been proceeding with construction work by violating the Honorable Court's order, the petitioner apprehends that the purpose of filing this suit as well as all the applications thereto would not be served unless and until the Honorable Court enforce its own order of injunction, either with the help of police or through the machinery of the Honorable Court, that is with the help of civil Nazir, as prayed by the petitioner. Hence, the petitioner filed the instant application to direct the bailiff of the Honorable Court civil Nazir to make a local inspection of the scheduled suit property described in the Schedule A to the present application and to take necessary steps to protect and preserve the same by stopping the ongoing construction over the same by enforcing the Honorable Court's order dated so and so, and to submit a compliance report there. So how this application can be premature? Because law says that the property in respect of what injunction has been granted, which is involved in the injunction matter, that is to be protected. That is to be protected. But learned trial court says, no, it is a premature. That suit is at the initial stage. Why? So my submission before this Honorable Court, that wrong has been committed by refusing my application, pass an order directing the civil Nazir to protect it. Suit is continuing because Lordship, this is now the day before yesterday, probably that suit was date was fixed and violation matter is there. We laid evidence. We are going to lay evidence on the evidence matter. That is different aspect. But in the meanwhile, properties to be protected, properties not to be inspected. That was refused. That is why his revision has been given. This is my submission. So accordingly, my revision may be allowed. At least direction may be given to protect the property. Suit will come, result will come, and the evidence will come. That is another aspect. But so far the injunction matter is concerned, the court granted injunction considering after hearing both the parties, all the parties, possession to be inspected, property to be inspected and protected. That is my submission as provided under the law. But that was refused.
Yes,
I'm appearing for the respondent number 2, my lord.
Mm.
Respondent number 1 was issued notice issued by this honorable court during the course of the hearing, my lord. This proceeding.
whether notice was served or not.
Notice was served, the respondent number 1 has appeared also, but unfortunately has not appeared. I'm only appearing for respondent.
Yes,
number
Mr. Bhuya, can we
Lordship,
conclude hearing today in view of absence of the counsel for the respondent number 1?
2. His
He's up
presence
to
is
the
otherwise
honorable court.
required, my lord. His presence is otherwise required, my lord, because
he is not.
he is
What
the,
happened? He is the defendant number, the opposite party respondent number 2 is the attorney holder of the respondent number 1. Because he allowed. Petitioner is one of the landowner, and the respondent number 1 is the one of the landowner. I am not on the merit of this case, but what happened, Your Lordship, that the respondent number 1 has executed the development agreement in favor of respondent number 2 in respect of his land, which was purchased along with me, and as other land. But in the development agreement, what he has done, he gave the boundary of my land. So that is why my land has been included and construction has been done. That is why that the respondent number 1, he is the attorney holder. Now the building is has been constructed by the respondent number 2. That is the position. The injunction was granted against both of them.
Yes, what is your submission?
I'm ready with my arguments, my lord, but my right over that particular property has been accrued from the respondent number 1. That is the reason why I have stated before the honorable court that his presence is required. Otherwise, I am ready with my argument, my lord. If I may take my lord to the my lord, page number 58, my lord. Okay.
Page number 58.
58, my lord.
Who is the counsel for the respondent number 1?
Yes, sir. G.J. Soikia and N. Das, A. Islam.
Okay, we'll take it up after some time. In the meantime, court master will contact the counsel.
At 2, my lord, if it's not inconvenient.
It can be. Mr. Bhuya at 2
Lordship,
o'clock.
Lordship.
We'll resume after 5 minutes. You can go. We'll take this matter at 2.
At 2, Lordship.
2 weeks time may be granted, lordship.
2 weeks, why?
So earlier offense also they took time, that may be fixed, time may be granted, but that may be fixed.
It's temporary waiting, lordship.
Pardon?
Waiting for waiting, lordship.
Heard Mr. A. Decker, learned counsel for the petitioner, and Ms. Kaur, learned counsel for the respondent number 1 to 5 and 7.
All the respondents.
All the respondents. All the respondents. Ms. Kaur submits that if it has already been prepared and the same has already been sent for vetting to the department. Department and press for granting her 2 weeks time to file the affidavit. Peer is accordingly allowed, list the matter on.
25th November.
Sort that.
22nd November.
22nd.
For 2 weeks.
22nd.
22nd November.
Lord. Deep level.
Item 14.
May I please your lordship?
Yes.
Lordship, this is an appeal which we have preferred against an order of injunction which was refused by the learned trial court. So far in this case, the appellant, being the plaintiff, he filed a suit, a declaratory suit, along with other, praying for some other consequential reliefs also for the learned court of civil justice senior division at Mogol. Now, lordship, here the order, lordship comes to the order of the learned trial court, while refusing the order of injunction is at page at running page 210, wherein the learned trial court has refused the order, and the observation which was made by the learned trial court is at page number 213, which is the last page of the memo of appeal. While refusing the order of injunction, the learned trial court didn't even cursorily discuss the prima facie strength of the plaintiff case, nor does it deals with the balance of convenience or the irreparable loss which was caused to the plaintiff. Though the events in this case, my lord, dates back from the year of 2011, I being the plaintiff, my lord, I entered into a lease agreement by the landowners who are arrayed here from respondent number 1 to 10. 1 and 2 particularly, and 3 to 10, my lord, and their predecessor, I entered into a lease agreement with them. Thereafter, I developed the soot land. I constructed all the furnaces for producing of the bricks. So I developed into a big industry, the said soot land. Now here, while my lease agreements were subsisting and continuing, the said landowners, they arbitrarily entered into a second lease agreement with the respondent number 11 and 12 in this said case for a period of 10 years, whereas mine, the period of lease was for 15 years. While the lease agreement was continuing, the said respondents, particularly 11 and 12, and in collusion with the landowners, at the first instance, they said that they were solving the issue with me by paying me all the compensation for what I have constructed over the soot land, my lord. So on that promise, I was just waiting for them to compensate me. But thereafter also, they committed repeated breach. Repeated injury was being caused to me on subsequent events. The way it is reflected over the pleadings which we have made in this said case, my lord. And so far, their lease agreement, while they had the respondent number 11 and 12, while they entered with the lease agreement with the landowners, it expired in the year of 2014.
No, you see, the court has issued notice.
Yes.
It has not dismissed your prayer.
My prayer was for not causing any disturbances or harassment or committing any kind of nuisance in the suit property, because, my lord, in this case, very elaborately,
Your prayer was not dismissed.
My prayer was not dismissed, my lord. Ex parte order of injunction was not being granted, which we fervently prayed before the learned trial court for allowing the prayer, ex parte prayer of injunction. But while dealing with the application, the learned trial court did not discuss the prima facie strength of the plaintiff's case, nor it dealt with the balance of convenience or the irreparable loss which was caused to me. Basing on that only, the trial court, even our contentions, our submission which we raised before the trial court, and the case laws which were referred, nothing was reflected over this said order, and therefore the learned trial court has acted illegally in passing the said order. For that reason, so we
will issue notice at this instance.
My lord, in this case, my lord, at this stage, since there is a repeated breach, repeated injury being caused to me, if the ex parte injunction is not being granted in my favor, my lord.
We will issue notice. What happened on 30th-10-2024 before the trial court?
Sorry, lordship.
The trial court has fixed the date 30th-10-2024.
Yes.
What happened on that day?
It was fixed for service report. All the respondents had not appeared. Then again it fixed again. When was the date? In December. December 12. The next date is fixed on December 12.
till then, my lord, it, at least this state, at least the said land should be preserved. At least the status quo order should be passed, Your Honor. That is our humble prayer.
We will issue notice, we will see on next date. Third, Mr. Your good name, please.
He does for Escalita, my lord.
He does. Learned counsel appearing on behalf of Mr.
Escalita.
Learned counsel for the petitioner. Learned counsel for the appellant. This appeal under order 43 rule 1 within bracket R read with section 104 and 151 of the Code of Civil Procedure is directed against the order dated 9/9/2024 passed in Meiji case number 51 of 2024. It is to be noted here that by the impugn order dated so and so, the learned civil judge Senior Division Dorang Mongoldoy has refused to grant ad interim temporary injunction in favor of the petitioner. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugn order dated so and so. Let notice be so to the respondent returnable in 2 weeks.
Lordship, it is fixed on 4th of December. The next date.
Before that day?
Before that.
Returnable in 2 weeks. Step be taken by registered post with AD and also by usual process within 2 days, 2 working days from today. List the matter on. No, but before December. Next date is fixed in 2nd December, before that date.
29 November.
Taragota will be fine. 22nd November. Additionally, dusty service is also permitted.
Lordship, connected IA is also there, preferred with the main appeal.
Here also notice will go.
Yes.
Item 15.
What happened, my lord? The petitioner power grid corporation, they install towers, my lord, for the purpose of the lines, my lord, electric lines. So while placing the tower, they are little, my lord, on at the place where the tower is placed, some damage is caused. So in the extent case, my lord, in 1998-99, my lord, the tower was installed. And then the government revenue department fixed the compensation. In 98, my lord. And that compensation was accepted by the petitioner, my lord, without any objection. Now in 2006, they filed a petition under section 10 and
When they have accepted the compensation amount?
99, my lord.
1999.
And now after 7 years, they have filed a petition for enhancement of the compensation. Well, some bold malware allegations are that so many trees and other things, malware. Well, so far tower is concerned, malware, they don't require more space. Now, in the before a district judge, malware, the philosophy stands to page 21. Lecture 2. Paragraph 4, malware. The instant petition is barred by law under Article 137 of the Limitation Act, was of action during the period 98-99 when the transmission line tower is erected and power transmission line is implemented. Now, your losses may come to page 24, my lord. The top, my lord. The petitioner accepted the notice in presence of his own witness, the Revenue Authority, Government of Assam, Hailakandi assessed the value of the surface damage compensation for an amount of rupees 10,000 so and so based on prevailing government approved rate issued under memo number so and so, as well as the rate furnished by the Assistant Agricultural Marketing Officer, Silchar, Department of Forest of Assam. The petitioner received the said amount without any objection. then para 10. The claim of compensation of the prisoner are purely wild imagination, bereft of reality and law, and fact of the prisoner preferred to file this petition after a lapse of 7 years, which implies that it is an afterthought and fabricated claim and liable to be dismissed and barred by law of limitation under Article 137 of the Limitation Act, as held by Honorable Apex Court in 1977. We had mentioned a lot about the judgment of the Supreme Court also that 137 applies, it is 3 years, my lord, maximum limitation. The trial court, my lord, last time, my lord, by the award, passed, my lord, assessed the compensation at 2,61,000. We approached this honorable court again demanded it back. My lord, yes, my lord, this honorable court we have argued also that the petition is barred by limitation. So matter is demanded back. And this time, my lord, again it has been enhanced to 7,08,000. Now, the main question is this, my lord, the question of assessment of compensation will come later. First thing, whether the petition is maintainable under law of limitation.
What was the direction of this court in the earlier order?
Yes, my lord. My lord, your losses will just come to my lord.
Page number?
Yes, page, my lord, 38, my lord, your losses. My lord, there, page 39, my lord, your losses will see. Notices the issue the present petitioner and receipt was same, it filed a written objection raising the issue that the petitioner's petition is not maintainable and same are hit under Article 137 of Limitation Act.
No, you come to the operative portion.
Yes.
What direction was issued by this court?
Yes. This is para 13, page 43. Miss case so sent back immediately Landed Court below parties which appears before Landed Court. Further court shall dispose the matter within the period of 40 days for that of appearance of the party represents.
And paragraph number 11.
Yes.
Remand the same to the learned.
Yes, it is remanded because
keeping in view the observation made herein above. What was the observation?
My lord, para 9. While deciding the point for determination, Landed Court will fail to give its finding as to whether court below can exercise jurisdiction in one side mandatory on the part of court of below. If there is a dispute, district judge can invoke the jurisdiction under section 16.3 in order to, as a plain reading 16.3, duly cast upon to look into the pleadings and not a glyph only, and on the satisfaction of the there exists a dispute regarding sufficiency of compensation of the parties can invoke the jurisdiction. There is no finding as to whether dispute between the parties concerning the sufficiency of compensation based on the section 10D of the Act. The Act is a special legislation give a jurisdiction to the district judge to adjudicate the dispute, if arises, between the parties before him in respect of the subject matter in the section 10D. If there is no dispute and the competent district judge has no jurisdiction, nor can it assume jurisdiction for giving a decision thereof. It can look into provision of section 16 of the Act authorizing any aggrieved party to move the court for recovery of the amount. In my opinion, this is concern is an adjudicator authorized by the said Act for deciding the specific issue subject to existence of a dispute between the parties in a summary manner. So the district judge must give a finding in respect of that there exists a dispute between the parties, and once district judge is satisfied giving reason thereof, the only judge can apply the judicial so. Keeping in view of the stand of the petitioner written objection in my view, Landed Court will fail to exercise jurisdiction giving its finding that there is a dispute between the parties concerning the sufficiency of compensation to be paid under section 10 of Landmark Act. Still pleading the written objection under the petitioner corporation that due compensation was paid to the claimant which were received by without any protest. The meaning of the word dispute is a controversy has been positive, negative aspect. It postulates the assertion of a claim by one party and denial of the other by held by so. But in the present case, there is no finding to the dispute arose in the parties. So the point for the limitation is goes to the root of the matter. Always. It can be, my lord, even in my lord, to the Supreme Court also it can be raised, my lord. My lord, now I shall place the two decisions to the Supreme Court, my lord, in this regard. One is, my lord, 1976 for SCC 634.
No, thereafter, the learned trial court, learned district judge Hailakandi
yes,
has framed one issue
Yes.
That is issue number 2, whether the instant petition is maintainable in the present format.
But our argument has not been considered here, my lord. Only, my lord, here, just gone, my lord. Your losses may see, para 12, page 49. Stop bringing the present claim. The opposite party in the written statement claim petition is not maintainable as the petitioner has already received compensation and received the same without also. But he stopped bringing the present claim petition. Though the opposite party submitted that claim petition is not maintainable in the present form and manner, and in fact remains that opposite party has acquired the land. Acquired, well, it is not acquired, my lord, virtually. Only placed a tower. Petitioner and awarded a compensation. The petitioner is not satisfied with the assessment of compensation made by so-and-so. As per section 10(16), any agreed party can file a petition for annulment of compensation. But that point has not been considered at all, madam. We have especially raised in the written objection, madam. And decision was also given, madam. So
What are
that,
the decisions of Supreme Court?
yes, madam. 1976 Supreme 4 SCC 634. Madam, I shall place paragraph 18 to 20 and 22, madam.
Paragraph
18,
number?
Paragraph 18. The alteration of the division as well as change in the collection of words in Article 137 Limitation Act compared to Article 181 of 1908 Limitation Act shows that applications contemplated under Section 137 are not applications confined to Code of Civil Procedure. In 1908 Limitation, there was no division between the applications in the special cases and other applications as in the said in 1960 Limitation Act. The words any other application under Article 137 cannot be said to be principle of legislation generis to be application under Civil Procedure Code other than those mentioned in Part 1 of the third reason. Any other application under Article 137 with the petition or any application under the Act. But it has to be application to a code for reason that Section 4 and 5 of the 1963 Limitation Act speaks of expiry of the period when court is closed, an extension of the prescribed period, and the applicant or the appellant satisfy the court that he has sufficient cause for not preferring the appeal or making an application during the such period. In the present case, application contemplated under Section 16(3) of the Telegraph Act are applications to a district judge, within whose jurisdiction the property is situated. Applications are contemplated if any dispute arises concerning sufficiency of compensation to be paid under Section 10 of the Telegraph Act. Section 10 of the Telegraph Act states that Telegraph Authority shall pay the compensation to all persons interested for any damage sustained by them by reason of excessive power mentioned in Section 10 of the Telegraph Act. Reference may also be made to Section 16(1), which states that if the exercise of power mentioned in Section 10 in the sort of property referred to in Clause D is resisted or obstructed, the district magistrate may order that the Telegraph Authority may be permitted to exercise them. The provision of the Telegraph Act, which contemplates determination of district judge and the compensation payable under Section 10 of the Act, indicate that the district judge acts judicially as a court, where by the statute matter referred to for determination of a court of record, with no further provision, the necessary implication is that court will determine the matters in the court. In so and so, in present case, the statute makes the reference to a district judge as a presiding judge of the district court. In many statutes, reference is made to a district judge under a particular title, while the intention is referred to court district judge. Telegraph Act Section 16 contains intrinsic evidence that the district judge is mentioned there as a court of the district judge. Section 16(4) of the Telegraph Act requires payment in the court for a district judge such an amount as the Telegraph Authority deems sufficient if the dispute arises as to the person entitled to receive the compensation again. Again, in Section 34 of the Telegraph Act, reference is made to the payment of the court fee and issue of the processes, both of which suggest that the ordinary machinery of the court in civil jurisdiction is being made available for settlement of disputes. Section 317 of the General Procedures Act that the district judge in any act of the central legislature means judge of the principal civil court of the original jurisdiction other than the High Court in exercise of the original civil jurisdiction, unless there is anything repugnant in the context. In the Telegraph Act, there is nothing in the context suggests that the reference of the district judge is not intended as a reference to the district court, which it means to be meaning of the implied the definition of the district judge under the Telegraph Act acts as a civil court in dealing with application under Section 16 of the Telegraph Act. The challenge the definition my lord, I'm coming to paragraph 23, my lord. Maybe, uh, 22, my lord. 21. The contents on which we reach is that Article 137 out of 1963 Act Limitation Act will apply to any petition or application order filed under the Act to the Civil Code with respect to, we differ with the view taken by the two judges bench of this court, because this is a three judge bench, my lord. The earlier judgment has been overruled and hold that section Article 137 of 1963 Act of the Limitation Act is not confined to applications contemplated under by or under the Code of Civil Procedure. The present petition in the present case was to the district judge of court. The petition was one contemplated by the Telegraph Act for judicial decision. The petition is an application falling within the scope of Article 137 of 1963 Limitation Act. For the reason we accept the appeal and set aside the judgment of it. But there is another judgment I am placing, my lord, 9711 FCC 412. One paragraph only, my lord, I accept it.
Paragraph number
3. Paragraph 3. Admittedly, the cause of action for seeking references arising of the date of service of the award under section 12(2) of the Act. Within 90 days from the date of service of the notice, the respondents made the application requesting the Deputy Commissioner to refer the case to the civil court under section 18. The date under the amended Act of section 3 of the Deputy Commissioner shall within 90 days from 1917 make a reference under section 18 of the civil code, which he failed to do. Consequently, the operation of by section 3B to the expiry of section 90 days, cause of action has accrued for respondents to make an application. The civil court will have prior to direct the Deputy Commissioner to make a reference. There is no period of limitation prescribed in section 3B to make the application, but it should be done within the limitation prescribed by the schedule to the Limitation Act. Since no article expressly prescribed the limitation to make an application, the residuary article 137 of the schedule to Limitation Act gets it. Thus, it could be seen that in absence of any such period prescribed under clause B of section 3 of 18 of the Act, the application should have been made within 3 years from the date of expiry of 90 days on the date on which was the person accrued to the respondent. Since the application has been admittedly beyond the 3 years, it was clearly barred by limitation. Since the court relies also the overall date. So, my humble submission, first point, to decide this, whether the petition is within time or not. Petition here, we have taken specific objection in the objection filed, and we have referred the case of this reported in 77, Supreme Court. 76 for SC6 report. That is the Kerala special report. I still refer to. So that point is to be considered first. Limitation goes to the root of the matter.
So no issue has been framed on that point.
On the point of yes, but no issue has been framed. Issue should have been framed on that point, my lord. First thing, my lord, the main issue is the limitation point.
Yes.
May be the lordships. First, my application come to page 16. The applications filed under Section 6 of the Indian Telegraph Act, 1925, there due section 4251 of the Indian Electricity Act, 1910, and answers of duty to the Indian.
When you have filed this petition?
Then come to page 7, 2006 file, then come to page 17, paragraph
2006.
Then come to 17, page 17, paragraph 3 and 4, may I read? Paragraph 3. Page 17, paragraph 3. My application. Got it. May I read? That the power grid erected 132 kV electric lines from Bodalpur to Mizoram, and the said line is erected over the homestead of the petitioner. That the office started cutting of trees. Then our petitioner wanted to resist the office. Then the additional deputy commissioner Sri so and so and so went there with police force that engaged labor to cut and remove the trees, and the petitioner were asked to shift his residence. So the petitioner had no other alternative and shift his residence. Then all the trees plants are not recorded by the departmental staff, of which it is recorded in their own room. That the opposite party assured the petitioner to give adequate compensation, but the assured and assured that after getting sanction, the government adequate compensation will be given. But the petitioner approached the OP physically and also submitted petitions after petition that the opposite party 2 and 3 told to the petitioners that other victims of the locality that sanction is not yet accorded, and took time after time. And the opposite point number 3 also visited the area of and on, assured all the victims and adequate compensation will be given to all the victims before puja action. But ultimately the petitioner and the other victim of the locality approached the body to the opposite number 2 and 3 on 3/10/2005. And opposite number 2 and 3 expressed the sanction is not yet accorded by the higher authority and denied to make any payment. Hence, under compelling circumstances, the petition filing the petition for getting adequate compensation as the
No, that is all right, but
when
how
they
do-
denied. Question is that when limitation start.
Yes.
Limitation may place certain decisions in this regard also. Lordship. The 137 Lordship of the Limitation Act. Or to other provisions. One that any other application for which no period of limitation is provided elsewhere in this division. 3 years, right side, when the right to apply appeals. When the right to apply the appeals. Here, I am placing the decisions in this regard also. Here, in this case, when they denied 2005, flatly, they accept filing WS did not come forward to prove their case. Nothing else. That in the board, the judgment, even the High Court judgment observed. They have not come, only written objections. They did not come forward to prove the case. Here is the case, petitioner submitted affidavit also cross-examined.
No,
He made
when the cause of action arose.
Arose for 2000, lawsuit 2005. When they
2005,
denied.
and when
When they denied.
No, when this
It is a
towers
continuous-
were erected in which year?
1999. But
1999.
1999.
Yes.
Then
So cause
when
of
the
action
adequate
arose on
co-
1999.
99
Yes.
is a continuous. Compensation has to be paid. It was not adequate. The section 10 the Telegraph Act says full compensation. Let's see, may I read the Telegraph Act 1985 section 10.
Copy. Telegraph Act. Yes.
1885 Telegraph Act. There is a case for enhancement. Simple amount paid, we are not satisfied, objected, that's why enhancement of application. Enhancement of compensation.
So in the year 1999, the towers were erected. And thereafter, what happened?
We demanded for adequate compensation.
When?
Initially, they paid 10,000 something. From thereafter demanded, and so thereafter 2002, we were demanding, they assured time to time. I read about this, my petition lawsuit paragraph 4, elaborated. When they denied, flatly denied, I will not give any payment. It is the year 2005. I submitted evidence also in this regard. If we are lawsuit, kindly Section 10 of the Telegraph Act,
No.
10D, may I read?
if the cause of
When I
action,
did not
no,
satisfy.
no, you say if the cause of action arose on 1999,
And
then when the
that
suit was
it-
supposed to be filed?
when they denied, they will not pay any further compensation. That's what the important section 10D. May I read? Section 10D. In the exercise of powers conferred by this section, the Telegraph Authority shall do as little damage as possible, and when it exercises those powers in respect of any property other than that referred to in clause C, shall pay full compensation to all persons interested for any damages sustained by them by reason of the exercise of those powers. Then section 16 of the Telegraph Act may read 3. Regarding dispute also, if any dispute arises concerning the sufficiency of the compensation, sufficiency of compensation to be paid under section 10, clause D, it shall on application for that purpose by either of the disputing parties to a district judge within whose jurisdiction the property is situated, be determined by him. If any dispute arises as the person entitled to receive compensation or as to the proportions in which the persons interested are entitled to share in it, the Telegraph Authority may pay to the court of the district judge an amount as it deems sufficient, or where all the disputing parties have in writing admitted the amount tendered to be sufficient, or the amount has been determined under subsection 3, that amount and the district judge, after giving notice the parties and hearing such of them as desired to be heard, shall be determined the persons entitled to receive the compensation, or as the case may be, the proportions in which the persons interested entitled to share in it. Every determination district by district judge under section 3 or subsection 4 shall be final. So lordships, when they flatly deny, the Article 137 says 3 years. May I placing when the last cause of action will fall, lordship? 2000. Here is the case, they did not come for to prove their case. Only written objection, nothing else. To AIR 2003, Supreme Court 2731. Then 2018 1 SCC, I am placing 1. 2008 8 SCC.
Which paragraph you have relied upon in this?
Now I am referring lordships. 2000 AIR 2023 Supreme Court 2731.
No, in the
Paragraph
first one.
31.
First one.
First one 2000 AIR 2023. Paragraph 31. Since a petition under Since a petition under section 11(6) of the Act 96 for seeking appointment of arbitral tribunal is required to be filed before the High Court or the Supreme Court, as the case may be, Article 130 of the schedule to the Act 96 would apply. That Article 1 should be read, that is put at lordships. Then paragraph 33, a plain reading of the aforesaid article would indicate that period of limitation in cases covered by Article 137 is 3 years, and the said period would begin to run when the right to apply accrues. Then 33. Further, it will be necessary to refer to section 9 of the Act 96 of the Act, which is continuous running of time, where once time has begun to run, no subsequent disability or inability to institute a suit for or make an application stops. It provided that where letters of admission to be estate of a creditor has been granted to his debtor, The running of the period limitation for a suit to recover the debt shall be suspended while the administration continues. Then paragraph number 34. 34, it was then 36. In the case of Major Indor Singh Rekhi versus Delhi Development Authority report AIR 98 Supreme Court, it has been held that the existence of a dispute is essential for the appointment of an arbitrator under Section 8 or a reference under Section 20B of the Arbitration Act 1940. And that a dispute can arise only when a claim is asserted by one party and denied by other on whatever ground. Mere failure to or inaction to pay does not lead to the inference about the existence of a dispute. As expression.
No, no, Mr. Borboya,
Lordship,
you say, but there is no dispute about the limitation of 3 years.
3 years. When it will actually, that is the question. That my case is when they deny. That's why I am placing. When it will, 3 years will start from.
When you have made the first application,
First application, it was initially they assured first application lawsuits. Page 17 lawsuit will find top. Application by the petitioner dated 17/5/2002, 18/4/2004, 12/8/2005, praying for providing compensation 28/9/2005, 3/10/2005, date of refusal by opposite party 2005 last. Refusal 28/3/10/2005. That is the application. In this case also was paragraph 36, 47, 58. And other cases was I also relied upon the 2018 1 SCC, paragraph 19. Under 2008 8 SCC, paragraph 10, 13, 15. 2025 SCC. 2008 SCC. 2018 1 SCC. 2018. So made it next last paragraph lawsuit and others I have lawsuit taken. Got this one.
Mr. Sahewala,
My lord.
tell me one thing.
Yes.
On which that the cause of action arose?
Yeah, because my lord, when they have received the compensation,
When they have received?
we appealed in 99.
99.
Yes.
No, you tell me the exact date.
Exact date is not with me, my lord. We are in the.
Then how can I count the limitation?
My lord, well, 3 years, my lord, your lawsuit, you see, my lord, we in the objection. In that case, your lawsuit to pull for the records because the compensation was fixed, my lord, at page 23, my lord, if you also see.
Only 10,000 you have to pay.
Yes, whatever it may be.
Is the case. That's
My lord.
the court below there's a fact.
The revenue authority, government of Assam, Hailakandi assess the value of the surface damage compensation.
Paragraph number?
Paragraph 8, my lord, continue. Top, my lord, 23 top. The petitioner accepted the notice in presence of old witness, revenue authority, government of Assam, Hailakandi, assess the value of surface damage compensation for an amount of which 10,753 based on the prevailing government approved rate issued under memo number so and so, as well as that furnished by the Assistant Agriculture Marketing Officer, Silchar Department for Sasa. The petitioner received the said amount without any objection.
It is their statement.
My lord.
They have not said.
My lord.
First thing, my lord, is there any scope, my lord, under Land Acquisition Act also, my lord, same thing, my lord. Under section 18, they have to file the petition for the district judge. First thing, they have to approach the deputy commissioner to refer the matter. Under new act also, same thing, my lord. Then if deputy commissioner does not refer the matter, they can file a petition directly to the district judge within the period prescribed. Because here, my lord, there is no scope for approaching the department again. Whom they have approached? By the revenue authority, because it is the amount fixed by revenue authority, my lord. And only, my lord, the tower, where tower is placed, my lord, there is only simple damage, my lord, not anything else. Because tower, wire is taken upward, my lord. And we have denied, my lord, there is no any house and other things. On merit, I am not placing anything. I merit also, I have the argument, my lord. But I am, today, my lord, I am placing the argument on the basis of limitation, my lord. First thing. If limitation, my lord, is decided, my lord, in my favor, I need no argument on merit, my lord. My question is this: limitation goes to the root of the matter. My lord, subsequent filing, they have not proved anything, my lord, that they have filed some petition. And only a bold statement, my lord, they have filed petition. Because whom they have filed? They have to approach the agriculture officer, my lord, the revenue department, because revenue department has fixed the compensation, my lord. We have not fixed the compensation. So they have to approach the, my lord, district judge within a period of 3 years, my lord. Sometime. 2002 is the last, my lord, death, my lord. Whatever may be the death, my lord. Even if your lordship take up, my lord, December also, then also, my lord, it has barred, my lord. In 2006, they have approached the district judge. Nothing has been said in the paper.
No, it appears that on 17/5/2002 and 18/4/2002, they have filed application.
No, whom, my lord, is there any scope for filing application? Once a compensation is fixed, my lord, is there any scope of filing application? My lord, 23 is the Arbitration Act. Arbitration Act section 21 says that we have to make a demand for appointment of arbitrator under section 21. If demand is made within 60 days, my lord, if it is not appointed, then the party can approach the High Court under section 11 of the Act for appointment of arbitrator. That is the judgment, my lord. Here there is no scope, my lord, for approaching the party again. Once the revenue department is fixed and the payment was made and they accepted it without the objection, where is the question of, my lord, again filing any petition? First thing, your lordship should see, my lord, that whether there is a scope, my lord. And they have not proved any application, my lord. Nothing, my lord. So my question is this, my lord, the question of limitation, my lord, the district judge should have considered it, my lord. The point, this issue should have been framed, my lord, first, that whether it is within the time or not. That aspect you can consider, my lord.
We remand the matter then to the district judge to decide the issue of limitation.
Well,
what is your submission?
My submission is that earlier question, it was a writ petition was filed, that since whether there is a dispute or not, to decide there is a dispute, then there is only why not maintainable. They did not come forward, there is a delay of 7 years, only the written objection, nothing else. They did not come forward to tell the court to place their case. Secondly, my learned senior friend says that the revenue authority has paid. Here is if the revenue authority's amount is not satisfied, then telegraph authority will pay full cost. That's section 10 of the language of the Act, lordship. I filed application to them. They're denied only by written objection. Here is the case. I have proved documents of my learned senior friend says that I have not submitted any documents. That and the rate documents that is also appear in the reflected in the judgment of the district judge, lordship. That one paragraph may I read, lordship. Page 51, lordship, bottom.
Page number?
Page number 51, bottom. Lordship, I'm sorry, prior to that, Lordship, issue number 3, may I read? Page 50. In support of his claim petition, the petitioner examined himself as PW, wherein he supported his claim petition and also proved various documents. The petitioner as PW submitted that his land was acquired for erection of over the land where he was residing along with his family for more than 60 years. The opposite parties asked the petitioner to shift his residence and thereafter entered his land. The petitioner had to prove bearing trees, so and so, so and so. Then Lordship, I without taking time, bottom Lordship, second line, last but one line. Moreover, the petitioner has also sustained loss due to damage to his dwelling house. During his evidence, he proved various documents which include Exhibit 1, assessment of loss, Exhibit 2 to 4. Petitioner is submitted by the petitioner before the opposite parties. Exhibit 5, letter from the district agriculture officer regarding income from various fruit bearing trees. Exhibit 6, price list for different types of trees. The facts by London cannot now deny. It was proved. They did not come forward to place their case.
No, we are on the point of limitation.
That limitation lost maintainability, only there is why not maintainable? That was why only things, nothing else. Page 50. Issue number 2, Lordship, page 49. The opposite parties in their written statement claim that the claim petition is not maintainable as the petitioner has already received the due compensation and he received the same without any condition. Thus, he stopped bringing the present claim petition. Though the opposite parties submitted that the claim petition is not maintainable in its present form and manner, but the fact remains is that the opposite parties had acquired the land of the petitioner and awarded compensation. The petitioner is not satisfied with the assessment made by the assessing authority as per section 10 and 16 of the Indian Telegraph Act. Any agreed party can file a petition for enhancement or compensation. The opposite party is neither adduced evidence nor specifically pleaded as to why the present petition is not maintainable, and that there is an inherent defect in filing the instant petition for enhancement or compensation. Hence, it is held that there is nothing to accept the plea of the opposite parties and the present petition is maintainable in present form and manner. Thus, issue number 2 is decided. So maintainable also decided. Here is the divisional power. High Court power is very limited. May I place the distance of this case of this honorable court worships? Now
No,
cannot change.
No pleading, my lord, This is say no pleading. We have specially pleaded. The limitation point. Limitation point has not been considered at all.
CPC,
Not considered at all.
civil code.
No issue is in fact.
Since it is a civil court jurisdiction, they have to prove their case as per order 10 rules. They have not proved anything. Their pleading. It does.
No, the question is whether if the plea is taken.
Proof is not required.
No, Mr. Barboya,
Lordships,
if the specific plea is taken by the petitioner,
7 years they have taken. This I admit, Lordship. That
then
that issue.
whether the district judge has framed any issue on that
On
point.
that point,
Yes.
it is absent. Admittedly, that is absent. That issue not
Then-
framed. On that issue, Lordships, time bound period may be if a Lordships expired that is required to remand the matter. The time by period it is about old case, Lordship.
Yes.
Mr.
On that
Sahayullah?
issue, Lordship
Yes.
is sufficient.
You show me the petition where that plea is taken,
Yes, ma'am.
page number.
My lord, I'll come. Well, 2 places, my lord. First, page 21, paragraph 4.
Next.
Then at para 8, my lord, continuing page 23, from the top and para 10. My lord, it was said, my lord, that petitioner received the said amount without person, 98 rupees, my lord. And then para 10, that judgment has been referred to, my lord, also. Which judgment I had left to lost.
Okay. Okay, we will see. We'll pass the order.
Yes, ma'am.
The question is, can we
Only that.
limit, can we ask the trial court to decide the issue within a fixed period?
Yes, all case.
No, no, no,
Only
there is
on
a
that issue,
decision
sir.
of Supreme
Nothing.
Court
Well, yes.
in the case of Allahabad. High Court of Allahabad High Court Bar Association versus State of UP. Their Supreme Court has directed that no time can be framed by the High Court.
There are
So that is a three judgments decision.
expeditiously, my lord.
Anyway,
Comparatively,
we will request the district judge
Expeditiously.
to make
only
an
on that
endeavor
issue. Regarding
to
limitation.
dispose of the petition as early as practical.
Order number 16.
Appeal, Lordship. This is an appeal for enhancement of compensation, Lordship. Appeal is against the judgment and award passed by the London Tribunal, Morigaon, Lordship.
What is the ground?
Ground is disability certificate has not been considered, Lordship. And moreover, Lordship, amount
Who
award.
had issued the disability certificate?
Lordship.
Who had issued the disability
This is a
certificate?
issue with the board.
Board.
Very good.
What was the percentage?
45%, Lordship.
45. Is it, was it permanent or temporary?
Permanent, Lordship.
Heard, Mr.
M. Talukdar.
M. Talukdar, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 18/4/2023 passed by the learned member, Motor Accident Claim Tribunal, Morigaon, in MSC, within bracket, injury case number 38 of 2015. Just to be noted here that by impugned judgment and award dated so and so, the learned district judge, no, learned member MSCT, Morigaon has directed the respondent number 1 to pay a sum of rupees 65,000 with interest at the rate of rupees 7.5% per annum from the date of filing the claim petition, that is 17/1/2017, till realization. Mr. Talukdar, learned counsel for the appellant, submits that while assessing the compensation, the learned member has not considered the disability certificate, which is exhibited before the learned member during the course of trial. And other ground is?
Amount awarded towards pecuniary and non-pecuniary heads are on the lower side.
And that the award, no, and the sum so assessed in the pecuniary and non-pecuniary head are in the lower side. And therefore, Mr. Talukdar contended to allow this appeal. The submission of Mr. Talukdar needs further consideration. At this stage, admit the appeal, issue notice to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record, place the matter after 4 weeks.
Item number 17, similar to your Lordship.
17.
Income.
And what is the ground here?
Income considered on the lower side, Lordship. Only 4,000 has been assessed by the letter. Monthly income 4,000, Lordship.
Income was in lower side.
Lower side.
Income.
And London Tribunal, Hubli, Lordship. And MSC is
Okay.
separate.
Education Department has filed an affidavit to the lordship.
Yes,
So I'm praying maybe come up next Wednesday, lordship.
Wednesday,
Yes.
36.
Yes.
Mr. S.U. Ahmed, Learned Counsel for the petitioner, submits that the Education Department has already filed an affidavit in opposition, and as such, the matter may be listed on
Next Wednesday.
Wednesday.
13th November.
Fair Lord.
I'm sorry, Lordship, I would like to mention one item 30, Lordship.
Eh.
Lordship, in this case, we have filed our objection that is not tagged. I did not check in the morning. So Lordship, let it come on 19th, Lordship. And in the meantime, we may be allowed to take steps by usual process on respondent number 2 and 3.
That was not allowed at the time of admission.
No, we had taken, the report has come from registry that the are not traceable, the steps we had taken. Because court had ordered the registry to find out.
Okay,
from
okay.
the-
On the pair being made by Ms. R.D. Mazumdar, Learned, you informed the other side.
He's-
Acha,
Actually, he informed me.
acha. As agreed by learned advocates of both sides, here is the salary. Right?
19th or 20,
After 19, 27th.
20, okay, Lordship.
27. In the meantime, the appellant shall take fresh step upon respondent number 23
And 3, by usual process.
by usual process.
Highly obliged, Lordship.
9.
Timing item 9.
I missed my name in the court list, that's why I could not be attended.
Item number 9.
9, my lord, in the first one.
Yes. Yes.
Rightly or wrongly, there is an order of status quo passed against us. That has not been challenged either by me or other by my learned friend. In the meantime, they came with an allegation regarding the violation. If they said so, let the matter be preserved, the suit property, and title suit will decide. With that effect, I have got no objection. If my learned
Yes,
friend
Mr.
agrees
Moya.
with that, subject to what my learned friend from the other.
That was the prayer before the Learned Trial Court. During pendency of the injunction order is there, we file violation application, we file application of police help, and finding no alternative, we prayed for preservation of the property, inspection and preservation of the property. That application was rejected. That is why I came before this honorable court. And my learned brother has rightly submitted before this honorable
It
court.
has not been challenged, my lord. Neither by us,
Yes,
neither by them.
Mr. Sensor.
Just subject to what is involved.
I won't take much time of my lord. My lord, they have filed the petitioners herein have, as plaintiff has filed a title suit, my lord. Along with the title suit, they have also filed an application under order 39/212, and an order has been passed. If I may take my lord directly to the order, my lord. Lord will find it page number 133, my lord. I'll only take my lord to the operative parcel. 133, my lord. Starts from 130.
Yes.
140, my lord, is the operative part, my lord, the order which has been passed, my lord. 140, the last paragraph of the particular order.
Yes.
The last paragraph, my lord. In view of the above discussion, prayer for injunction is granted, restraining the defendants from, particularly the defendant number 1 and 2, from proceeding with any construction work over the scheduled property described in Schedule A to the application, as well as from alienating and transferring the same to any other intending purchaser or purchaser till depositor of the suit. My lord, now this particular order was being passed. This particular order is an ex parte order, my lord, where the suit has proceeded ex parte against me, and against which I have already filed an application before the learned trial court for setting aside of this particular order, my lord, and the ex parte order, so that I may be allowed to file a proper application, proper reply to the application which they have preferred under order 39/212. I may be heard, and then thereafter the order may be passed, my lord. This is the current position, that the application over there is still pending adjudication. They were given a copy, served a copy of the said application, but till date they have not filed any reply to that. So that is pending adjudication. It has been pending for a very long time, my lord. This is the current. Thereafter, my lord will see. Subsequent to which, my lord, if I may take my lord to page number 136, 176, my lord. This is the application annexure number 10, my lord. This is the application.
170?
170, my lord.
6.
6 it would be, my lord. 176, my lord. My lord has it. This is an application under section 155, my lord. Sorry, 151, my lord. Kindly see this application, my lord. An application under section 151 of the Code of Civil Procedure for enforcement implementation of the order dated 39/2021. The injunction order, my lord. May I please take my lord to the prayer portion of this particular application, my lord. 182, my lord. It is therefore prayed, my lord has it. 182. It is therefore prayed that your honor would be graciously pleased to admit the application and further be pleased to direct the officer in charge of Bordoma Police Station to implement and or enforce the order dated 39/2021 passed by the Honorable Court in Miss J case number so-and-so arising out of title suit number so-and-so by restraining, preventing, this is very important, my lord, by restraining, preventing the present opposite party, defendant and their man agent, servant and employees for making and or continuing with any construction over the Schedule A land with immediate effect and to use force if necessary to enforce the same and pass such necessary order or orders as your honor may deem fit and proper for the ends of justice. Upon perusal of this particular prayer made herein, and if I may take my lord to the order 39 rule 7, the provisions, though it has been filed under section 151, but the prayers made herein are exactly the same that has been provided under order 39 rule 7, my lord. And my learned senior friend herein has stated in the morning that this application is pending adjudication, but it is not. This has already been decided, my lord. This is the order, my lord, passed. My lord will see that the petition, when it starts from annexure D, it is written as petition number 425. Here it is petition number 425, the order, section 150 on the CPC for implementation of the order. Towards the end, my lord, I won't read the entire, my lord, this petition of, it has been allowed, my lord. And the concerned police officer has been asked to go and inspect that particular application, my lord. So, in a way, the prayer made in the particular, which is under challenge before this honorable court, which he has made by providing, by citing that particular section, the exact prayer was made in section 151 of the this application. And it has been decided, it has been allowed, my lord. Go further ahead, my lord.
No, Mr. Senso, you see, the issue before this court is now whether the suit property is to be preserved or not. Till disposal of the.
It has already been done, my lord.
Already been done.
By the lower court, by this honorable court also. I'll show how, my lord. My lord, there is an IA, my lord, that will find. And it is a futile exercise that has been done by moving this particular application. Already this application has been infructuous, my lord. If my lord may take then application, IA application number 222/2024 filed by them, my lord. It has already been disposed of, my lord. It has again been filed under section 151, and the my lord clearly see the prayers in that particular application. My lord has it. It is therefore prayed that your lordship would be graciously be pleased to admit the application and be pleased to call for the report from the officer in charge of Bordoma Police Station regarding enforcement of the order of injunction dated so and so passed by the Honorable Court of Civil Judge number 2 Senior Division at Guwahati in Miss J case number so and so in title suit number so and so as directed by the Honorable Court by order dated so and so the present revision application. Pursuant to this application of the petitioner was allowed. A report has been submitted, which is there in the report, my lord. The report dated 6/8/2024, my lord. It is there in that very file, my lord. On the basis of the report, the IA was dismissed, my lord. Now, this is the second time this same exercise has been done. Once by the, my lord, order of the civil judge, second by order of this honorable court, my lord. Twice the same thing has been done, my lord. If I may take, my lord, to the, my lord, the report, my lord, which has been submitted, my lord.
At page number?
It would be there, my lord. It
In
has been
the-
filed, yes, my, it has been filed, marked, my lord, with a tag, my lord. 6/8/2024, my lord.
Yes,
By the
submitted by Bikram
Inspector of Police, yes, my lord. May I please read the order, my
Birajchandra
lord?
Ramsiari.
Yes, my lord. May I please read the order, my lord, report, my lord?
Hmm.
This has been addressed to the registrar, my lord. With reference to the subject cited above, I have the honor to report you that the order copy passed by the honorable judge party have so and so, my lord, as he then was, on 5/6/2024 in connection with CRP was received at Bordemuk Police Station. Accordingly, ASI so and so Kolita of Bordemuk Police Station was entrusted to execute the order via so and so dated so and so ASI Kolita, and staff of Bordemuk Police Station visited the dispute place at Maskwa under wherein construction company Native Tree Developer Private Limited, that is me, undergoing residential flat construction working, all the constructions were on disputed part of the land was stopped. The manager of the construction committee, Sri so and so, was found at the site, issue a copy of the court order and directed to stop construction work. Again, on the basis of the information provided, he again goes with the order. Once he goes to the police station, he gets it enforced, then he again goes to the police station, my lord. This is the second part, my lord. Again, on the basis of the information provided by the petitioner on 3/8/2024, the place of this was visited by Inspector so-and-so ASI, Topon Kolita and staff of Bordemuk. At the place found some workers gathering at the place for working purpose. All the workers were dispensed from the place, submitted for favor of your kind perusal and obligation. So, my lord, the order has been enforced thrice, my lord. I was wrong. Once by the order of the civil judge senior division, and twice on the basis of the order passed by this honorable court, my lord. So the entire act, the entire exercise that the petitioner is praying by way of this present petition, or the petition that he has filed before the learned trial court, will the court again go and do it for a fourth time, my lord? The same thing. Because order 39 rule 7 is very clear, my lord. If I may take my lord to the detention, preservation, inspection, etc. of the subject matter of the suit. The court may, on the application of any party to a suit, or on such terms as it think fit, may order for detention, preservation, and inspection. So detention is not there, my lord, in this particular case. Preservation has already been done thrice. Inspection also has been done, and report also has been submitted by before this honorable court, my lord. So what is left, my lord?
No, does it mean that visiting the scheduled property and dispersing the person gathered there amounts to preserving the suit property?
My lord, the exercise would be the same. Because if my lord may come to the prayer which he has made, my lord. His application is at page number, my lord, 284, if I'm not wrong. An application filed by the plaintiff under order 39 rule 7 section 151 of the Code of Civil Procedure for preservation and or inspection of the scheduled suit property through the bailiff Nazir of the honorable court, and to enforce implementation of the order dated so and so. The prayer is at page number, my lord, 292, my lord. It is therefore prayed that your honor would be graciously pleased to admit this application, and further be pleased to direct the bailiff of the honorable court civil Nazir and or to appoint any other person as commissioner to make a local inspection the moment he comes up with this word commissioner, then other provisions of law will attract, my lord. 26, my lord. 26(9). That is the reason why it has been rejected. I'll go to that order also. To make a local inspection of the scheduled suit property described in Schedule A to the present application and to pass an order to protect, preserve the scheduled property by stopping the ongoing construction. He is exactly praying for the same thing, my lord, which he has prayed in the application. Worker over the said scheduled property during pendency of the suit, more particularly in view of the so-and-so, passed in so-and-so, my lord. And to submit a compliance report thereon and pass such necessary order. So, my lord, he is praying in this particular suit that someone must be directed to go to that particular place, stop the construction, and as the construction has been stopped, the compliance report should be submitted to the court. That has already been done, my lord. By an exercise done by this honorable court. This is his prayer, my lord. And the manner in which he has prayed this particular application, it does not attract this particular section. And therefore, the honorable trial court has rightly rejected it, my lord. Citing that in page number 316, my lord.
Page number?
316, my lord. This is the order, my lord. Starting from page number 313, my lord. Last but third paragraph, my lord. That apart, the suit is in initial stage. The reason this initial stage has been cited, my lord, after passing of this particular order, he again has filed an application for implement of some parties, my lord. That has been allowed, and those parties who has been implemented, they are yet to appear before the court, my lord. Still, trial is yet to begin. That being so, the petitioner for local inspection is found to be premature. Necessary for local inspection is subject matter of consideration after evidence of the party. Rightly said, my lord. It is an observation vis-a-vis the prayers that he has made, my lord. And therefore, this particular order was passed while Section 151 application was still pending. And Section 151 application was subsequently allowed, my lord, to approach the concerned police station and get the order implemented, my lord. And that is the reason why this honorable court has also allowed that particular order, my lord. Because the entire order was passed, my lord, ex parte against me.
Okay. Yes, Mr. Bhoya?
Lordship, my learned friend rightly, but I forget it. That application was for enforcement of the order of the injunction. 151 application. And accordingly, learned trial court ordered to enforce the order with the police help. That order they have challenged before the honorable court, and honorable court rejected the revision. Rightly, it has been informed to the honorable court by learned brother. Even then, when they proceeded with the construction work, we filed violation application with this pending. Now, that is why we filed the application for preservation of that property. Inspection, detention, and preservation, not the enforcement. Enforcement is separate thing. You go and enforce it. It is a direction. And detention, preservation, inspection is required by the learned trial court. But the learned trial court, but under that application was filed under Order 39, Rule 7. It is the duty of the learned trial court to preserve the property at the time of pendency of the suit, because injunction order is there. Injunction order is there directing the respondents not to alienate, not to transfer, not to make construction over the Schedule A land, this my land. We have implemented some of the parties who they are, because in spite of their having the order of injunction, they sold it out. They sold some flats. So having come to know, we implemented them as a party and they are parties to the suit. That is different aspect. That is to be decided in the suit. So in the meantime, what remedy open for the plaintiff petitioner, that to approach the honorable court to preserve the property so that that cannot be alienated. That was the prayer. That was the prayer. Inspection is different, enforcement is different.
Okay.
Lordship.
Hello. In that case, my lord, it can be done this way, subject to what all my learned senior friend, my learned friend. Let the matter be, let the property be kept in preservance till he gets a favorable order. Because he told that he have filed an application for setting aside that order. Once that will be allowed, he can challenge this order to an appeal.
We will pass the order.
Lordship.
Pleasure.
Item 18, 19, and 20.
May I please, your lordship. Lordship, earlier occasion, lordship, my learned friend was directed to file affidavit on several occasion, lordship. But my lord, on the several occasion, my lord, day after day, my lord, they are taking day. My lord, the petitioner, lordship, petitioner, the my lord, the senior most assistant teacher or graduate teacher of a high school, lordship. When the lordship selection process was completed, depriving the right of the petitioner, my lord, the imputed select list was prepared by the respondent authorities, lordship. My lord, you might be learned friend in the required time. My lord, my prayer is to stay the operation of the impugned order, lordship. Lordship, kindly for a moment, lordship, kindly say order of 542024, lordship. Order of my lord Justice Nair.
Yes, madam.
Lordship, Mr. Esbor appendix. So he has told that he is waiting for instructions. Sometime may be granted.
No, if we go by the order dated 5/4/2024, we have to consider his interim period and let Mr. Bora come, wait for some time.
My lord, Mr. Bora contacted me, my lord, friend will appear before this honorable court and make prayer.
Let me try if he can come.
Okay.
Means I'll go and see.
Okay, after some time, wait for
Yes,
some time.
21.
Please, your lordship. Lordship, they are supposed to file affidavit. Lordship, I have been instructed by S Quad that instruction is awaited, your lordship. Elementary.
Pardon, Miss,
A Das, lordship.
learned counsel for the petitioner and madam.
H Terang P, your lordship. Actually, I'm not in the elementary
H.
department.
Teran P, a learned counsel appearing on behalf of Miss Esquan,
S Quad, your lordship.
learned standing counsel for the education department, elementary education. Miss Teran P, a learned counsel appearing on behalf of Miss Esquan submits that as per her instruction, the instruction from the department is awaited and prays for granting some time. Here is accordingly allowed. Is the matter after 1 week?
So 1 week, 2 weeks, your lordship, because instructions will come again, they might have to file an affidavit also, your lordship.
No, in the month of September, 3 weeks time already granted. Thereafter also time was granted. But 2 weeks time.
Item 37.
Regular first appeal, my lord, on the original decree and order passed by the trial court, my lord. It says first appeal is a question of fact and appeal, my lord. Law and fact, my lord. It may be admitted, my lord. Yes, my lord.
Mr. Mukherjee, you go for respondent number?
Number 1.
1.
I don't have a copy. A copy may be furnished to you.
Okay.
Respondent 1, Vinod Gary.
When you have filed this appeal,
Appeal file, my lord, limitation, I limitation allowed, limitation petition, my lord,
Acha.
condemnation allowed, my lord, that is
Okay.
fine, my lord. After that, it is
Okay.
coming.
Heard, Mr. Your good name, please?
Yes, Soikia, my lord.
S. Soikia, learned counsel for the appellant.
Mm.
And also heard Mr. DJ Mukherjee, learned counsel for the respondent number 1. This appeal under section 96 of the Code of Civil Procedure is directed against the judgment and decree dated 17/9/2022, passed by the learned civil judge Srirang Kajalgaon in TS number 16 of 2021. It's to be noted here by the impugned judgment and decree dated so and so. The learned civil judge Srirang at Kajalgaon has decreed the counterclaim of the defendants. First, the memo of appeal and the grounds mentioned therein, and also first the impugned judgment and decree dated so and so. Admit, issue notice to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Since Mr. Mukherjee, learned counsel, appears on behalf of respondent number 1 and receive notice, no formal notice is required to be issued to respondent number 1. However, extra requisite copy of the petition will be furnished to him during the course of the day. Receive call for the record from the learned trial court. List the matter after 4 weeks.
Discuss one, discuss my lord, first.
Lordship, that may be decided after copies have to me, because there is a decree in my favor.
Okay. Notice. Since Mr. Mukherjee, learned counsel for the respondent number 1, appears and receive notice, no formal notice is required to be issued. However, extra requested copy of the petition will be furnished to him during the course of the day. List the matter after 4 weeks then?
My lord.
Is there any urgency?
Title execution started, my lord. It is
Notice to
started?
the other
Yes, ma'am.
respondents will also be required. Your Lordship. There are 2 more respondents.
The petition will.
Petition can you
Oh, it notice যাব, my lord. Because execution procedure already started, my lord, unless my lord, impugned judgment is state, my entire petition will return.
Mr. Mukherjee, you want to file objection here?
Yes, Your Lordship.
So, after 1 week
Their
then?
suit was dismissed, Your Lordship, and counterclaim was decreed. So there is only one appeal here. They have not challenged the dismissal of the suit, I think. The appeal is against decree of the counterclaim. I need to file an objection regarding that.
The notice is returnable after 1 week. Mr. Mukherjee submits that he will file objection in this petition. And price for granting him time. Prayer is allowed, list the matter after 1 week.
Just for hearing under order 41, rule to CTC. Item number 24. Item 24.
None appears for the appellant on call, rest shall list the matter after. Mr. Mukherjee, you are here? RSA 94?
24.
I think that was mentioned in the morning. I was instructed to be mentioned, no?
Item number 24, no mention.
RSA number 94, Your Lordship.
Yes.
Yes, Your Lordship, I can. Lordship, it is against a concurrent finding, Your Lordship. I was the plaintiff. My suit was dismissed, Your Lordship. And thereafter, my appeal was also dismissed. In this case, Your Lordship, I purchased a plot of land
by a registered sale deed. And thereafter, patta was also issued in my name, Your Lordship. And then thereafter, I was ousted by the predecessor of the seller, Your Lordship, from the plot of land. Against that, I filed this title suit, which was dismissed. And while dismissing the title suit and also while dismissing my appeal, the learned courts did overlook the fact that there was a patta issued in my name as well. Lordship, there are judgments which says the factum of issuance of patta cannot be brushed aside like that, Your Lordship. And there was also a registered sale deed. There was no challenge to that in my favor. In this regard, regarding the issue of grant of patta, I would rely on Omniyovala Dr. Mr. Mukul Adhikari of this Honorable Court, Your Lordship. In para 9, Your Lordship, of this document, the court has held that under Assam Land and Revenue Regulation, a person who is a patta holder is deemed to be a landholder and he has permanent, heritable and transferable right of use and occupancy in his land subject to Section 9 of the Assam Land and Revenue Regulation. If a person, in order to establish his title, produces a patta, must be given due weightage inasmuch as a patta is issued in accordance with the provisions of Section 17, read with rules, and that must be considered to be a document of title, and this is always considered to be a document of title. Further, the record of rights as provided in Section 14 and Section 41 of the Assam Land and Revenue Regulation shall also be deemed to be correct unless contrary is proved, and that presumption which is attached to the records of right under Section 40 and 41 must be given due weightage, and that is what was done by the learned court and appellate court in this case, Your Lordship. In this case, in the present case, Your Lordship, if Your Lordship perusses the judgment, which is at page 25 onwards, Your Lordship. In the list of exhibited documents, plaintiffs, we have the plaintiffs in page 44. Exhibit 1 was the original patta that was produced and exhibited, Your Lordship. And also the certified copy of Jamabandi. These were not considered by the learned courts below, Your Lordship, while deciding the list.
In which paragraph of the judgment,
Lordship,
both the courts below have dealt with that exhibit 1?
Lordship, page 37, in deciding issue number 4, 7 and 8. Now coming to the issues, Your Lordship, in page 35, the issues are there. So 4, 7 and 8 issue, Lordship. 4 is whether the suit is bad for non-joinder of necessary parties, whether the plaintiff has right, title and interest over the suit land by virtue of registered sale deed number so-and-so, and 9, whether the plaintiff is entitled, whether the defendant number so-and-so are liable for eviction, 4, 7 and 8. Coming to page 37, these 3 issues were decided, Your Lordship. If I may read from the first of page 37. During the course of argument, learned counsel for the plaintiff submitted that plaintiff is able to prove his right, title and interest, including his sellers over the suit land. As such, the plaintiff is entitled for the decree. It is further submitted that the patta and the records of rights as proved by the plaintiffs respectively as exhibit 1 and 2 clearly shows that exclusive right, title and interest of the seller over the suit land from which he derives his title. Moreover, referring to the regulation 41 of Assam Land and Revenue Regulations, the learned counsel for the plaintiff further submitted that court is to take presumption of title of pro forma defendant number 1, that is the seller, and 2 in respect of the suit land, and the title legally and validly vested upon the plaintiff. In this connection, learned counsel for the plaintiff has relied upon the judgment of the Honorable Court and so,
It is also submitted by the defendant have not made any counterclaim in this regard for cancellation of either the patta or the registered sale deed in my favor. Registered sale deed having number so and so, as such the same remain intact, which is sufficient for holding the right title in interest of the plaintiff. In the counter, then it is discussed, your lordship, and then the finding of the court, it is page 40. Page 40, page 41, para 20 would be relevant, your lordship. Para 20. Moreover, I am of the considered opinion that the pro forma defendant number 2 has right title interest only over 3 lesses of land out of 15 lesses of land. Lesses of land, which she would get if this land equally got partitioned among the legal heirs of Lakshmikanta Rai. As such, she did not have any right to transfer the land more than her share. As such admitted position, she already transferred her share to pro forma defendant number 3 on execution of sale deed. But there is not mention in the fact either in the plaint or the written statement of the pro forma defendant as to how and by what mode she transferred her share to pro forma defendant number 1. Hence, in my considered opinion, the pro forma defendant number 1 had no title and interest over the suit land. As such, she could not transfer any land to the plaintiff. Therefore, the registered sale deed number so and so executed by the pro forma defendant number 1 in favor of the plaintiff, which proved by PW1 as Exhibit 5, is nothing but a paper document which cannot confer right, title, and interest upon the plaintiff, and same is illegal and void, having no binding effect upon the defendants or the legal heirs of Lakshmikanta Rai. Moreover, Exhibit 1 and 2 alone could not confer title upon the pro forma defendant number 1 or 2. I am of the further considered opinion that the plaintiff has miserably failed to discharge his initial burden of proof by establishing his right, title, and interest over the suit land as per section 101 of the Indian Evidence Act, your lordship. It will be 104 of the present BSA, your lordship. If
At page number 4 of your memo of appeal,
lordship,
these are grounds or these are suggested
Substantial-
question of law?
substantial questions of law, your lordship. Now coming to the substantial question of law number 1, suggested substantial question of law number 1, your lordship. I am relying on section 110 of the Indian Evidence Act, your lordship, which has become 115 of BSA, newly enacted BSA, your lordship. It says about burden of proof, your lordship. If I come to the facts, your lordship, to the provision, your lordship, it says when the question is whether any person is owner of anything of which he is shown to be in possession. I was in the possession of the suit land, your lordship. The burden of proving that he is not the owner is on the person who affirms that he is not the owner. The court has held that I miserably failed to discharge my burden of proof because the document, the sale deed was disbelieved and the patta was not considered, whereas I was in possession, your lordship.
So you were reading section 101
Section
of
110 of Indian Evidence Act.
101 or 110?
110, 110. In this case, your lordship, I have produced my registered sale deed and the patta of my seller to show that I am the owner. The burden of proof under 110 of Indian Evidence Act would be upon them to show that I am not the owner. court has held that I have failed to discharge my burden of proof to show that I am the owner of the plot of land. And this may be a suggested question of law. Number 5 can also be a proposed question of law, Your Lordship, because they have never challenged.
So, according to you, this 1 and 5.
5.
1 and 5.
1 and 5, Your Lordship. And if during the course of hearing any other substantial question of law may arise, that may be. Because Your Lordship, they have never challenged my registered sale deed. There was no challenge to the patta or the entry in the mutation record in the name of my vendor.
Heard Mr. Bijay Mukherjee, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 14/3/2023, passed in title appeal number 9 of 2017 by the civil judge, learned civil judge Boygaon. It is to be noted here that by the impugned judgment and decree so and so, the learned First Appellate Court has dismissed the appeal and thereby upheld the judgment and decree dated 28/8/2017, passed by the learned Munsif North Salmara, Avayapuri in PS number 41 of 2013. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree so and so, passed by the learned civil judge Boyano and also by the Munsif North Salmara, Avayapuri. This second appeal is admitted on the following substantial question of law. Number 1, whether the learned courts will err in law in deciding the suit, as well as appeal in contravention of section 110 of the Indian Evidence Act. More so, when the exhibit 1 and 2 had clearly established the right, title, and interest, copulate position of the vendor of the plaintiff at the time of selling the suit land to the plaintiff. Number 2, whether the courts below were justified in dismissing the suit as well as the appeal when the registered sale deed, on the strength of which the plaintiffs purchased the suit land and the mutation as well as patta in the name of his vendor were never challenged by the defendants. The court may also consider framing of any other substantial question of law if found necessary at the time of hearing of the suit after giving notice to both the parties. Issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also by the process within a response to the. Someone has appeared on behalf of the
Initially,
defendants,
someone has appeared.
respondents.
Mr. C. Sharma was appearing initially.
লাস্টের লাইনটা কি করলো? Recessal call for the record from the learned Horsefellow. This is the matter after 4 weeks. He will inform the council. Till then, we will not upload the order.
Lordship, if your lordship pleases, in place of learned courts below in the substantial question of law, learned trial court and the first appellate court.
Pending items 18 to 20.
Record was called for, record was here, my lord, record was presented, my lord. Thereafter, my lord, it has been sent back to prepare the paravas comment, my lord. Lords will give me some time to file my affidavit.
There is a observation.
The record, if record doesn't come, my lord, the part of the record of the selection list, I have a photocopy of the select, minutes of the proceeding, my lord. I've kept it, my lord, but this is the minutes, my lord. After the minute, there will be all the mainly this is the selection of the headmaster. Their appointment will be subject to outcome of the petition. And there are private respondents already filed Ukalatnama. I think there because their item number 18, their names have been reflected. And they have already joined. Let me find my affidavit, my lord. Will be subject to outcome of the petition.
When?
After 2 weeks, my lord. Because I have not formally they have not received the entire instruction.
So what about this interim period then?
Well, interim period will status quo isn't because the piece so the selected person already joined.
Already joined.
Already joined. Ultimately, lordship, the only thing is the status quo and they have already joined. Status quo will go against the petitioner only. Because the status quo will I will file my affidavit, lordship will decide everything, well, then the outcome of the petition will prevail.
Lordship, kindly see, first order is on the 27 March 24, Lordship. And today is the Lordship, 6th of November, Lordship.
Record was there and they have returned it, my lord, because to prepare the affidavit, my lord, the paravas comment.
Respondent are taking advantage, Lordship, that they have joined. My lord, the salary may be held up, Lordship.
No.
Yes, Lordship. Otherwise, Lordship, my lord, on several occasions, my lord, they have Lordship, my learned friend and other.
On that ground, salary cannot be held up.
Lordship will give me 2 weeks time. In the meantime, I will file my affidavit.
No, I will give you 1 week time. You file affidavit.
Lordship.
Heard Mr. Saleh, learned counsel for the petitioner. Also heard Mr. Bora, learned counsel for the BTC, standing counsel for the petition. Mr. Bora submits that he has received the record, received the file, but returned the same to prepare the affidavit and pressed for granting him 1 week time. And returned the same for preparing paravise comment. Then he pressed for granting him some time. Or we'll fix it at Mr. Bora.
But Lordship will fix it after 10 days. In the meantime,
10 days.
10 days.
Okay, all right. 29. 29 November. 19.
Let it be first of, this is some difficulty, my lord. Let it be 2nd December, my lord, Monday.
2nd December.
Lordship.
Yes,
Okay.
Item 26.
No, Lordship, please. So can I feel I have challenged the insurance pending of people. I am the defendant in the suit, my lord. The plaintiff filed the suit for my ejectment from the suit premises on the ground that I defaulted in payment of the rent. And but I denied the tenant and pleaded that your lordship would see, pleaded that I am not your tenant. Lordship would see there. Page number 14 is the plain to your lordship.
document claim. He stated that I am the tenant. He claimed that he purchased the premises in the year 2006. And since then I defaulted in payment of the rent. But here Lord will see my written statement, page number 20. Page number 20. Here I have especially stated in your lordship, paragraph 2 and 3, that the paragraph 2, the schedule of the deed number 13805 of 2006 does not speak of the transfer of the suit premises as the land schedule of the deed does not speak the sale of the standing substance standing on the land schedule. Suit premises have got independent identity and they existent. It has one construction. Suit premises is the first floor of the building. Suit premises is the first floor of the building. The plaintiff claimed that he purchased the land, but his salary does not speak of the suit premises building. That is a building. That I have come here. The document which does not contain the independent consideration money of the sale of the suit premises cannot be treated as a sale of the suit premises by the document as such. The deed number such and such is not the instrument of selling the suit premises. The plaintiff in this suit, the plaintiff has miserably failed to produce any document which especially speak of the selling of the suit premises. But in the light of the pleadings, the court below from the issues in many years.
But Mr. Upadhyay,
My lord.
you have suggested some substantial question of law.
Yes. That is
as many as
page
five
number 12.
5 questions.
My lord. Yes.
Out of this 5 question, you show me which one is the question of law.
Question number 2.
Because
issue number 2,
this
whether the
second
finding of the
appeal
court
is
in respect of the issue number 3 is perverse. It is a question of law. Substantial question of law. This is also substantial question 1, whether the plaintiff is the owner of the suit premises in spite of the fact
no, that is a question of law or question of fact.
No, the substantial question, not question, substantial question of law.
How?
Because your lordship see
Whether plaintiff is owner of the suit premises or not, that is a question of fact.
No,
how can it be a question of law?
No, my lord, your lordship will see here in spite of the fact that sale deed of the exhibit 1 of the plaintiff does not speak of it is a substantial question of it can be. If your lordship is think that it is not a substantial, then second one.
That is also question of fact.
Not second. No. Whether the finding of the court below is in respect of issue number 3 is a perverse or not, it is a substantial question.
You tell me, can this court appreciate the facts while dealing with a second appeal under section 100 of the CPC?
Not substantial. What is substantial question of law? The substantial question of law means my lord.
Yes, Mr. Goswami, you might have gone through the suggested questions.
Lordship, not that only. Lordship, this is a case under the Urban Area Rent Control Act. In under Urban Area Rent Control Act, there is a provision for first appeal. Here, Lordship, case has been decreed. I am the landlord. Case suit has been decreed. Against that order, he filed appeal. Appeal dismissed. Thereafter, Lordship, he has filed revision petition. Revision petition dismissed. Now, second appeal. Under the Urban Area Rent Control Act, section 8.
So second appeal is
my lord, I had filed the revision. But revision was dismissed with the liberty to file me the second appeal. This is the order I have annexed. This honorable court has directed me to file the second appeal.
But
page number 73. Page number 73, your lordship. If he complete Lordship, I can argue Lordship.
Yes.
You will get chance. Initially, I had filed the revision, my lord. He is correct. But the honorable court said that no, there is also, my lord, I had taken the plea of the adverse position also, and other plea also, and being in looking to the my plea, the court said no, second appeal lies. Good hell. So what to do? Still, I should file the revision in spite of this judgment. So court held it is second appeal is maintainable. Now, lordship, sorry.
Yes.
Lordship, though I have claimed as many as five, lordship have framed the substantial question of law, one or two.
No, that's all right. Court can frame. But you show me which is the substantial question. What substantial question of law has to be framed by this court?
This substantial, whether the finding of the court below is in respect of the issue number 3, purpose, issue number 3.
What was the issue number 3?
Issue number 3, the relation, whether the plaintiff,
there was any relationship
of landlord and tenant between main defendant and performer.
That is a question of fact.
No, question of facts and question of law, you are also very thin margin. Otherwise, there no question, no substantial question will be framed.
If there is no substantial question of law, definitely court will not frame.
No, my lord, this is also your lordship. I think the issue number, the substantial question number 1. 1, 2, and 3 also, whether the learned trial court having not decided the issue number 4 was not decided, my lord. Issue number 4 was not decided by the learned trial court. And however, it was decided by the, not issue number 4, lordship. The first appellate court said that trial court did not decide this issue. I took up this issue to decide in exercise of power conferred under Order 41 Rule 24 of CPC. But he also did not decide issue number 4. Issue number 4 is, lordship, whether the plaintiff purchased the suit land and premises. There are the two things, suit land and premises from the performer defendant. Thus became the owner thereof. This issue was not decided, even undecided. So how can we learned first appellate court said that the trial court did not decide, I decide. But he also not correctly, not decided, my lord. So I have framed this issue, whether the learned trial court having not decided the issue number 4 ought to have remanded back the suit to the learned trial court instead of taking up the issue number 4 petition and result in the exercise of power. It's a substantial question of law. And whether the court below failed to give a finding in issue number 4 about the purchase of the suit premises by the plaintiff from the performer defendant.
So there is concurrent finding of both the courts below.
Concurrent finding, yes, madam. Concurrent finding in respect of the other issue, not in respect of the issue number 3. Issue number 3 was not decided by the learned court below. The court below means trial court.
But the appellate court has decided.
Appellate court also partly decided, but not fully.
Yes, Mr. Goswami.
You have finished, Lordship, then I can.
Yes.
May I take your Lordship to the urban area input flag? Section 8. Section 8 of the urban area input flag. Super.
Yes.
A landlord or a tenant aggrieved by any decision or order of the court under provision of section 457 of the Act shall have a right to appeal against the same, and as if such decision or order were decreed in a suit for ejectment of the tenant from the house, and such appellate court decision shall be final. No further appeal lies, and that has been decided by the Honorable Court and Supreme Court. So, Lordship, I'll place the judgment of this court, where this court has already held that no further appeal lies. Para 10, Lordship.
Paragraph number?
10.
Yes.
At this stage, Section 8 of the Assam Arbitration and Control Act 1972 is relevant. Section 8 of the Act 1972 bars filing second appeal in High Court. According to Section 8, decision of the first appellate court is the final decision, and no appeal beyond this that is provided to the same city. So this is the Urban Area and Control Act case, and suit has been filed long back in 2008, and nothing has been paid by him. He filed appeal dismissed. Thereafter, he filed revision petition also dismissed, with a observation regarding maintainability of the second appeal. So second appeal is not maintainable in provision of Section 8, and this court, as the Supreme Court has held, appeal is not maintainable. Secondly, Lordship, in this particular case,
Mr. Goswami, his main contention is that there is a direction in the direction of this court in the civil revision petition.
That is why, Lordship, that order, Lordship, will file at page
73.
76. Page 76.
Yes.
Para 8, Lordship, last portion. However, liberty is given to the petitioner to file appeal under Section 100 of the Code, subject to same being permissible in terms of the mandate of Section 100. Subject to mandate. So mandate is Section 8. And that is why, Lordship, it was placed before the Honorable Justice Borua, and Borua want to dismiss this petition, but until then I am not appearing, filing Okaltama. That is why case was pending.
No, you appear without Okaltama.
I have appeared subsequently.
You perhaps
As per direction of the Honorable Court, I have filed a Okaltama after the case was listed before Honorable Justice Borua, and this Justice Borua also want to dismiss this petition because
No, Mr. Upadhyay, let him complete.
what was the stand taken in the WS, Lordship? Kindly see, he is a permissive occupier according to his written statement. Lordship will kindly see WS of the page 20, written statement of the defendant.
Page number?
Page number 20, look. Page 20 is the WS of the present appeal.
Yes.
Now, page 25 is the relevant portion. Page 25, land portion, Lordship middle portion on 2/2/1993. Lordship got it.
Yes.
On 2/2/93, pro forma defendant took rupees 50,000 to refund on demand by the defendant and her late husband. On during February 1994, in pursuance to seeking to reside on the suit premises by the defendant, her husband, pro forma defendant, allowed us to live there for a short period without any condition paying rent, and accordingly from February 1994, defendant along with her husband started residing in suit premises. On April 1994, pro forma defendant demanded occupying the suit premises. He asked to vacate the premises. In the meantime, pro forma defendant failed to refund rupees 50,000 taken by him in the house of the husband of the defendant. Defendant and the late husband refused to pay the rent of the suit premises nor vacated it. So he is a permissive occupier of the suit premises of the earlier my landowner. So there is no counterclaim in the WS. No counterclaim has been made regarding Lordship his right of paying 50,000 rupees to him, my original owner of the land, my vendor. He said 50,000 rupees to my vendor before coming to the house in concern, at the first floor of the house, and he is under occupation, so he is not entitled to give to rent to me. That is their plea. There is no counterclaim denying my title by his title, by adverse position. Now, how second appeal is maintained? Trial court has declared a suit with paying rent for the area rent as well as the cost of the suit. First appeal dismissed with cost with payment of the area rent with 1,000 rupees, again an additional 1,000 rupees, still that nothing has been paid, and now he is filing second appeal. Lordship will decide regarding maintenance of second appeal, because without deciding the maintenance of second appeal, Lordship will not formulate second appeal, admit the second appeal. First, Lordship will decide whether maintain the second appeal, and Lordship may fix this matter any day for maintaining the second appeal, whether second appeal is maintainable. On the basis of this judgment, as well as I have the Supreme Court judgment, the second appeal is not maintainable, because first appellate court and the trial court is the deciding question of fact, and what they have formulated in the second appeal, these are question of fact. The second appeal, Lordship will not decide question of fact. Regarding ownership of the land, ownership of the house, I have exhibited the sale deed that has been proof, and now he is denying my title without claiming an adverse position, without any control claim. And suit is pending since 2008. He is not paying any single penny.
No. His contention is that he claim adverse possession.
Where is possible? There must be some counterclaim in the WS. Adverse position should be by a counterclaim. I have pointed out the WS. Last portion, page 27. There is no counterclaim. If there is a counterclaim, then he can claim adverse position. Page 27 is the last portion. There is no pair for counterclaim. Page 27, last portion. There is no prayer for counterclaim. How can he claim adverse position? It cannot come on a vacuum logic. There is no counterclaim in the WS. Adverse position should be pleaded and prayed. There is no plea for prayer for adverse position. Claiming right title interest against the true owner. No prayer. Without having the prayer in the suit, this is suit, regular suit. And Supreme Court has categorically stated that in case of Urban Area Rent Control Act, title is not a matter to be decided. It is landlord and tenant relationship. My original vendor's wife has been examined as a witness. She has deposed that he is paying rent 1,000 rupees per month till date of sale, and thereafter he stopped paying rent to me. So this second appeal is not maintainable, because the original, when the revision petition was dismissed, it is specifically observed subject to the same is permissible in terms of the mandate of section 100 of the code. It is not maintainable under section 8. I have placed the judgment of this honorable court that second appeal is not maintainable under Urban Rent Control Act. He have to file a regular suit, or he have to make a counterclaim in the WS that he claim adverse position against the owner. No prayer in the counterclaim in the WS. Now, how can he in vacuum he can plead the second appeal? There is a counterclaim. You have adverse position. So this appeal is not maintainable. And I want to place a judgment of the Supreme Court, which Supreme Court has categorically stated that in 1999 3 SCC 72
Yes, relevant paragraph.
Para, Lordship, 3, last portion. Appeal is required to be heard, Lordship, got it? On the question to be formulated. However, the respondent at the time of hearing of the appeal has a right to argue that the case in the court did not involve any substantial question of law. Provision of section acknowledge the power of High Court to hear appeal on a substantial question of law, though not formulated by it, with the object of ensuring that no injustice is done to the litigant where such question was not formulated at the time of admission, either by mistake or inadvertence. Second, para 4. It has to be kept in mind that right of appeal is neither a natural nor an inherent right attracted to the litigation. Being a substantive statutory right, it has to be regulated in accordance with law, in force at the relevant time. Condition mentioned in section must be strictly fulfilled before second appeal can be maintained. No court has power to add or enlarge this ground. Second appeal cannot be decided merely on equitable grounds. He is not claiming any counterclaim in the WS. Now he is showing that there is a plea of adverse position. How it can be decided at the second appeal. Secondly, para 6.
Yes.
For the middle, where a point of law has not been pleaded or is found to be arising between the parties, in absence of any factual format, a litigation should not be allowed to raise the question as a substantive question of law in second appeal. Here, Lordship, the plea of adverse position has not been taken in WS with a prayer. The mere appreciation of fact or documentary evidence or the meaning of entries in the contents of a document cannot be held to be raising a substantive question of law. But where it is found that the first appellate court has assumed jurisdiction, which did not face it in it, same can be adjudicated in the second appeal, treating it as a substantive question of law. Where the first appellate court is shown to be exercised its discretion in judicial manner, it cannot be termed to be an error either in law or procedural requiring interference in second appeal. And last portion, para 7. Such a finding are based upon appreciation of evidence and being the finding of last court of facts were binding upon the parties, learned single judge of the High Court, therefore not justified to hold that there was no independent proof with regard to the time impression, not necessary. So in this particular case, both the question, trial court and appellate court has appreciated the fact, and thereafter, the plea that has not been taken before the trial court, nor neither in the appellate court, now he is raising that adverse position, which is in vacuum logic, that cannot be argued in the second appeal. And second appeal initiative is not maintainable under Urban Area Rent Control Act, barred by Section 8.
We have seen many revision petitions preferred against the
Revision petition preferred. Revision petition, that is why revision petition is entertained, and revision petition maintainability is, revision petition is always maintainable. When second appeal, there is no provision for second appeal, revision petition is always maintainable. That is why also under 227 always preferred revision petition under Urban Area Rent Control Act. But here already they have preferred a revision petition. Revision petition has been not maintainable. This court has already held. With liberty, if it is maintainable, subject to maintainability, he can approach the second appeal. Liberty has been given subject to maintainability. That is subject to maintainable. Again, I am reading what is not subject to. Yeah, complete. However, liberty given to the petitioner to file appeal under section 100 of the code, subject to same being permissible. Again, page 76. Subject to same being permissible in terms of.
I have seen it.
So, subject to maintainability. So, subject to maintainability, that is why, Lordship, I am arguing that second appeal is not maintainable.
Yes, any reply, Mr.
Yes,
Upadhyay?
my lord. Your subject, your lordship, para number 8, given the petitioner to file an appeal under section 100 of the subject to the same being permissible in terms with the mandate of the section 100 of the code. That means if I cannot show any substantial question of law, lordship will not admit it. That mandate is here, but
No, it is subject to maintainability.
No,
Subject to same being permissible in terms of the mandate. So is it permissible? So we have to consider that question first.
No, my lord, not required. Because this order was passed in his presence. He participated in the proceeding. He participated here, your lordship. His name is here. He was heard. He was heard.
That was heard on the basis of my petition. I have filed a petition for
No, no,
vacating
you
this
have
order.
not filed any petition. You.
Lordship,
you
petition
appeared in the
number, this
revision.
petition number is 1354 of 2024.
You have-
This petition has been filed by me. On this petition, this order was passed.
No, no, no. It's not so. Court held that is since I have taken the other plea. The other plea when
Adverse question.
adverse person, etc. You have clearly mentioned, clearly mentioned. Your lordship will see para 4. The court put a specific query upon the learned counsel for the petitioner as to why the revision application has been filed involving the jurisdiction under section 115 of the code, not a second appeal. The learned counsel for the petition submitted in view of the finding of the fact arrived at that the defendant is a tenant coming within the ambit of the Assam Urban Area Rent Control Act 1972 for short act, and in view of the bar under section 8 of the said act, the revision application has not been filed. My lord, what he submitted, that I had also stated the same thing before that court. But the court said that be that as it may, the learned counsel for the petitioner further submitted that the petitioner continued to agitate that the petitioner had acquired the right over the suit premises on the basis of adverse possession, and the asset suit which was filed was barred by limitation. Taking into account the specific stand taken by the petitioner in the opinion of the court, the said stand cannot be taken up in a proceeding under section 115 of the code, in as if the question of the title over the suit premises is the question that same goes outside the purview of the act of 1972. Considering the above, the court therefore hold that the instant proceeding under section 115 of the code is not maintainable. That not maintainable, lordship will see. Inasmuch as an appeal lies under section 100 of the code. So now that was decided. That is why my learned friend informed me that I have already prepared an appeal before the Supreme Court, and perhaps the matter will be decided. He informed me. He informed. Because if that issue is taken up for decision, that means the entire this order has to be revised. That cannot be done. If your lordship take up the maintainability, that means the entire this judgment has to be reviewed. That cannot be done.
No, you come to the last portion of the paragraph number 8.
Yes. No, 8 is in the light of the section 100. Whether I have been able to.
No. Merely because some observation has been made by a coordinate bench of this court.
To the same
Can I? No, Mr.
In terms with the mandate of section 100.
Mr. Upadhyay.
Lordship.
You see, only because some observation has been made by a coordinate bench of this court, can this court ignore the provision of section 100?
Well, lordship, your lordship can do one thing, that you send back this matter to that court. That court will be.
How?
Yeah, that court.
Why this court will refer the matter to that bench?
May refer. No, otherwise I think if the lordship.
We'll examine the maintainability.
The maintainability.
Issue of maintainability under section 100.
Then this court already held that lies, appeal lies in para 7. Para 7, that court already held.
Mr. Upadhyay.
Learned coordinate bench already held that the considering the above. Para 7.
Mr. Upadhyay.
Para 7.
Second appeal is maintainable only on the point of substantial question of law.
Yes.
And this question of adverse possession, that is a question of fact. Can this court enter into that aspect?
Adverse possession,
go into examine that
No, whether-
who is in the adverse
No, no.
position, who is in the position, and since when.
Exactly, your lordship will see the adverse position if, since I have taken that plea in my written statement. So in view of that, court said that that plea.
No issue was framed on that point.
Issue was framed.
Framed.
The issue was very much. 6A. Lordship will see that issue was framed. 6A. Whether the defendant occupied the suit premises against the will of the performer defendant since 1/4/2094 and acquired the title upon the suit premises after 12 years. Issue is here, 6A. Issue is here. In view of that issue, that is why we would held that the second appeal lies. Second appeal lies. Court held second appeal lies. Para 7 of the judgment. And thereafter also, my lord said that the mentality should be decided. Here, para 7, I again read, considering the above, the court therefore hold that the instant proceeding under section 115 of the court is not maintainable. And if your lordships, suppose, assuming that your lordship take up the plea of maintainability, then your lordship will say that a revision is maintainable. Then I have to go again.
No, we'll not say that.
No,
this court will not make any such observation.
I shall be remediless then.
This court will examine the issue.
No, I shall be remediless.
Keeping in mind the mandate of section 100.
I must have some remedy. Then I shall be remediless. If your lordship says that second appeal is not maintainable, then the revision must be maintainable. Either revision or second appeal.
No, second appeal is barred by the act itself.
No,
Section
the
8.
The court has granted me
No.
liberty.
Maybe.
No, then lordship.
So
if your
ignoring the
lordship-
provision
if your
of
lordship held that the
ignoring
second
the statutory bar, this court cannot entertain any second appeal.
No, the court has taken that your lordship will see entire judgment. Your lordship will read entire judgment.
Okay, we'll see. Mr. Goswami, any reply?
Lordship, already without any prayer for adverse position, now arguing the adverse position. Already both the court has affirmed the trial court judgment and revision petitions dismissed. So there is an appeal, appeal is not maintainable at all, and there is no substitution.
Okay. Heard Mr. Upadhyay, learned counsel for the appellant, and Mr. Goswami, learned counsel for the respondent. Order reserved.
Obliged.
On mentality.
Pardon?
On mentality.
We'll pause the order.
Item 24.
Sorry, Lordship. I finished the matter. So I could not appear, Lordship. I'm for respondent number 1 in this case, Lordship.
Your good name, please?
C. Sharma, Lordship.
Mr. C. Sharma, learned counsel for the respondent. Also heard. So how many respondents are there?
6 respondents.
6. So you have to take a step among the rest of the respondents. You furnish a copy to him. So notice will go in IA also. You can file objection if you want. 4 weeks.
Item 27, matters for orders.
27, 28, Lordship.
No, 27. It's not ten. And then 27.
27, Lordship, as per Office Note 4/11/2024, AD card duly signed by the respondent number 9, Lordship. Earlier notice was already served upon all the respondents, only respondent number 9 was left, Lordship, so we taken again step. And now respondent number 9, AD card duly signed. Step by usual process has not been received till dates. As per AD card's report, Your Lordship.
Okay, heard Ms. R. Chaudhary, learned counsel for the appellant. Then Madam,
R Yadav for respondent 1.
for respondent number 1. Office
20,
note,
20 and
none
21.
appears for the
I appear for respondent number 21 and 22, Your Lordship. on
21
behalf
to
of-
22. Mr. Rampe, learned counsel for the respondent number
on
21 to
behalf of S.
22.
Khanickar, Your Lordship. Behalf of S. Khanickar.
On behalf of
Khanickar.
S. Guar,
S. Khanickar.
S. Konikor, okay. S. Konikor. Office note dated 4/11/2024 indicates that duly signed AD card in respect of the notice issued to the respondent number 9 has been received by the section. But respondent number 9, despite service of notice, remain unrepresented today. Office note dated 4/11/2024 indicates that LCR of both the courts have been received, and as such, the matter is ready for hearing. Justice shall list the matter in usual courts for hearing.
28.
28, Lordship. I have not gone through the office note, Lordship. In 27 only I have done through the last office note, Lordship. Earlier, Lordship, 2, 3, 4, all are served. Earlier, Lordship, LCR was not received, but here in 27, LCR already received from the same title suit, Lordship. One counterclaim was there, so we have preferred 2 appeals. So, Lordship, in item 27, as per office note, already filed from title suit and title appeal received. And those were examined also, Lordship.
So both these appeals are against the common
Same
judgment and all.
Lordship. There is a title suit and the counterclaim, Lordship. So, Lordship, case is ready for hearing. If your Lordship fix a date in the month of December or January, Lordship.
Heard Ms. R. Chaudhary, learned counsel for the appellant, and Madam Jadhav for respondent number 1 and
Respondent number 1.
1. And Mr. Rampe, learned counsel for the counsel appearing on behalf of Mr. Konikor.
21 and
Respondent number 20.
21 and 22.
In this appeal, 21 and 22 are not there. Not there. It's there. 21 and 22. And 23 also,
21, 22.
and 23. They are minor.
Yes, Lordship.
It is submitted at the bar that the service completed and LCR has already been received in respect of, no, in connection with RSA number 58 of 2023. And as such, the matter may be listed for hearing in usual course. Accordingly, it is provided that the SSL list both the matter for hearing in usual course. Will not fix any date. I say.
January, Lordship. If your Lordship.
No, no, will not fix any date.
29.
Obliged.
But,
This is an appeal against the order of injunction. So we filed the appeal under order 43, rule 1R. And last appeal, Lordship admitted the appeal and in the interim matter, I notice was issued. And the
Lordship, I am for respondent number 1, 2, and 3, Lordship.
they have appeared today. And so far as performer respondent number 4, let's see. Dusty 5 is notice was served.
Have you filed affidavit here?
We have filed, but it does not come. It is not tagged. We have already filed in the last week.
How many respondents are here?
1, 2, 3, they have appeared, and
Performer.
1. So this is not appearing because they are with us.
One, two, three appeared.
Okay. But not with them.
You are for respondent number?
1, 2, and 3, Lordship.
1, 2, and 3. And in respect of 4?
4, Dusty service, the notice was served, but that affidavit has not come.
When you have filed it?
Yesterday.
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 Why don't you inform the court in the morning? Then we could have called the matter. It is about 4 o'clock now.
Now, I'm there.
Heard Mr. Khatunier, learned counsel for the appellants, and Mr.
A. Singh, Lordship, on behalf of R.K. Bhuiya.
A. Singh, learned counsel for the
Respondent
learned
number
counsel appearing on behalf of Mr. R.K. Bhuiya, learned counsel for the respondent number 1, 2, and 3. Mr. Khatunier submits that notice upon respondent number 4 has already been served by Dusty Mott, and an affidavit has also been filed before the registry of this court, but the same has not been placed on record. Accordingly, it is provided that registry shall list the matter on Monday.
Lordship, there is an IA. Some time may be granted for filing objection.
IA for?
IA for
interim injunction.
Okay.
In that matter, in that case, the whole matter may be heard. Instead of hearing on the IA, the whole matter, because it is a matter of injunction, it should be disposed of early.
Then after 1 week then?
Yes.
After 1 week?
In the meantime,
IA,
they have
you
filed
take
their-
down Mr. Singh, learned counsel for the respondent
Lordship,
number
2
1,
week-
2, and 3. Submits that he will file objection in this petition. And price for listening the matter after 1 week. Pair is allowed.
Well, they are paying for 2 weeks.
2 weeks time may be granted, Lord.
2 weeks.
For filing and.
Okay, 2 weeks.
Well, in
So
this
put the matter 2 weeks.
Yes. The law court record is not required because it is only against an order of injunction. And the suit is proceeding, that's it.
Okay, all right.
So, yes, justice may observe that, otherwise. The earlier occasion, Lordship Kali say,
counsel for the
Lordship, earlier occasion, while the appeal was admitted, a record was called for.
Okay. Mr. So-and-so learned counsel for the appellant submits that file order dated 1/10/2024, the record of title suit number 253 of 2024 was called for, but the same is not required required at this stage. And accordingly, it is provided that no reminder is required to be issued to the learned trial court for sending the record to this, for transmitting the record to this court.
Lordship, fix a date after 2 weeks.
I'll give it. I'll give it.
Yeah.
31.
Problem.
Lord, affidavit has been filed today.
Today?
Yes, ma'am.
That is Lordship. Lordship, today they have filed an affidavit in opposition. And the Lordship may allow us 2 weeks time to file affidavit in reply. 3 weeks may be given. Lordship.
2 weeks.
3 weeks time may be given. And Lordship,
as per the office note, Lordship, service has been completed, Lordship. So on next occasions, Lordship may allow that matter be come under admission column, Lordship.
Whether all the respondents are represented?
One, three, and seven.
One?
3 and 7.
1, 3, and 7.
2 and 5.
Heard Mr. Mazhar Bhuiya, learned counsel for the petitioner, and Mr.
R.B. Goswami.
R.B. Goswami, learned counsel for the respondent number
2 and 5.
2 and 5, and Ms. Dharampe for respondent number 1, 3, and
3 and 7.
1, 3, and 7. Mr. Mazhar Bhuiya, learned counsel for the petitioner, submits that in this petition, service has already been completed, and the respondent number
Hello, I'm entering for 2 and 5. Sir.
2 and 5, 2 and 5, and submits that he has already filed affidavit in opposition, but the same is not placed on record. Placed on record. However, Mr. Mazhar Bhuiya, learned counsel for the petitioner, submits that he may be granted 3 weeks time to file reply to the affidavit in opposition filed by the respondent number 2 and 5. Accordingly, it is provided that justice shall list the matter after 3 weeks.
Lordship, the matter may be listed under admission column on next
Okay.
session.
No, rest they will automatically listed in the admission column since service completed.
Lordship, but on last 2 occasions, Lordship, it is put under admission, order column, Lordship. But service
Okay, rest shall list the matter in the order column since service has already been completed.
admission column.
32.
Right, Lordship.
Right, Lordship. Lordship, we have filed affidavit with regard to Dusty service. So, my lord, that is in the record, my lord, we have
What's that?
filed on. We have filed on, my lord, 5th September 2020.
Respondent number 6.
Respondent number 6. Other official respondent, they have appeared, my lord. Now the service is completed, my lord. So matter will be fixed for admission.
Heard Mr. Emali,
ML.
learned counsel for the petition, and also heard Ms. Escobar, learned standing counsel for the respondent number 1, 2, and 1 to 6, 1 to 5.
1, 2, 4, and 5.
1, 2, 4, and 5. In respect of 3,
3 DC Lordship.
who will represent?
Lordship, government advocate will represent. I'm appearing here, I'm appearing only for departmental, as a departmental advocate.
None appears for the respondent number 3, though service has already been completed. Mr. Ali submits that service upon respondent number 6 is effected by Dusty Mood, and an affidavit to that effect has also been filed before this court on 5th of September 2024. And since service has already been completed, the matter may be listed for admission hearing.
Next week, my lord, any date.
List the matter.
Suspension matter, my lord, a prolonged suspension. So, my lord, an early date.
Urgency in the suspension. Oh, how long you were in suspension?
My lord, 1 year complete.
1 year.
He was
Departmental
suspended on
proceeding?
2nd of November 2023.
DP started.
Nothing, my lord. Nothing.
The
no
so-called
memo,
notice
no-
served.
No charge sheet has been filed. Nothing, my lord. Only
Nothing.
suspension order. Even the suspension order is not renewed, my lord. That's why, my lord, we have challenged. They have violated the
Weeks time,
apex court
Lordship.
judgment.
2 weeks time may be granted. 2 weeks time.
No, madam, it is expressly illegal. You cannot keep the person in suspension for indefinite period.
Lordship.
Mhm. It cannot be beyond 3 months. There is a judgment of Supreme Court.
Ajay Chaudhary, my lord.
Chaudhary, okay.
Ajay Chaudhary.
Ajay Kumar Chaudhary. Ajay Kumar Chaudhary. Yes. Ajay Kumar. No,
Ajay Kumar
Ajay
Chaudhary.
Chaudhary.
Supreme Court judgment.
25th November. Monday.
Okay, 25th November.
Obliged.
33 and 34.
Now, if the connected ideas in both the cases, 33 and 34 are applications for amendment of written statement at the appellate stage on the grounds as stated in paragraph 3 of the application. So at this stage, only notice may be issued to the other side. I have already served notices to them, copies of to them.
Lordship, we will file objection on this matter.
That's all.
Why?
Heard Mr. Mazhar Bhuiya, learned counsel for the applicant, and Madam
Yes, Ahmed.
S. Ahmed, learned counsel for the respondent number. How
One
many
sole
respondents?
respondent.
Sole respondent. Sole respondent.
2 weeks may be granted.
My lord,
This
it become-
application under Order 6, Rule 17 CPC is preferred by the applicants for amendment of written statement filed in title suit number 4 of 2016, which was disposed of in the Court of Civil Justice. File can be by judgment and order dated 28/2/2020. Against which RSA number 148/2023 has been preferred and the same is pending before this court. Ms. Ahmed, learned counsel for the respondent, submits that she will file objection in this application and prays for granting her some time. Here is allowed, list the matter on. When?
2 weeks, my lord. I will be away.
2 weeks.
4 days.
4 weeks.
I will be away for medical treatment of my wife.
Okay. 4 weeks.
Please, over.